8:54. Your also confirmed that judgment in July 2025. Now, also directed that control limit is fixed and if there will be a delay that they do seriously.
Will issue notice. Issue.
Now, in the meantime, they are going to.
Meantime, they are implementing.
What they are doing, they are, because of delay, now they are juniors. So juniors, they are doing the promotion without regularizing this. There are nothing to do, that's a different cause of action, but contempt is.
Issue emergent police notice. Returnable on. Returnable within 2 weeks. Post on. Who is a development secretary, ST/SC Development Department?
Yes, madam.
That candidate belongs to scheduled caste.
No. That's a department.
STSC schools.
Okay. And director, secretary and director are the contemnants.
Yes.
Let the police notice go. Tell them if they do not do, they will face some difficulty. Okay. Some date. Which date you have given? 22nd May. Which is that date? Friday. Suppose if we do not sit there.
2nd May. 2nd May.
No, 22nd May it will not be. 2 weeks it will be that way.
Okay.
Within 2 weeks. All right. Working
By 22nd May. 22nd.
No, that will be last working day. We will be taking only urgent matter.
We try because not granted 2 weeks time.
All right. On 22nd May at 10:30. Okay. Subject to availability of brother.
I may pardon to. I may. Your Lordship.
This bench. Another bench, na? Wait.
I'm sorry.
And then the pending of criminal proceeding vigilance case and department proceedings, Your Lordship.
When the
Earlier, Your Lordship, earlier the writ appeal has been already decided by the then Chief Justice Muralidhar.
identical matter, so nothing remains.
Even with the caveat that it will be subject to the result of the writ appeal, Your Lordship.
The subject matter of this intra-court appeal by the state is substantially similar to the one treated by a coordinate bench of this court in writ appeal number 805 of 2021 and a batch of other appeals between state of Odisha and another versus Joseph Parikh, etc. First stop. So then notice has to be issued.
Lordship Officer.
First, in view of that, issue emergent notice. Returnable within 10 days.
We have been 7670
We are covered by Kushtal normally.
Covered?
But you see, Lordship, the apex courts have held that only that much amount of service from the contractual period be taken for the calculation of the minimum pension, Your Lordship.
Same order what we have made. Identical matter we have said, na? Have we changed the factuals here?
Minor math.
Any delay?
Minor delay.
Yes, Your Lordship.
Delay. Delay for
435
Here
days.
is also for 35 days delay. What is the explanation offered for the delay? Delay to be condoned. Kindly see, delay is 430, 432, 435 here. Okay, IA number 1947 of 2024. 48. Identical.
But item 4 also similar.
For
Item
similar.
4, 5 and 6 also, my lord.
4, 5 and 6. Delay will condone delay.
My lord, great.
Only.
619 my lord.
Huh?
For quota, delay is 619.
Will condone delay.
Because they are getting the benefits, my lord.
That's what. And the main, on main matter, you are succeeding. That's what. In 5 and 6, no notice is issued, na?
No notice has been issued.
Even 4, 5, 6, no notice is
No notice is issued.
The 5, 4.
3 is also same, Your Lordship.
Huh?
In addition to notice, your lordship,
3 is also same.
Yes, Your Lordship.
You're right.
my lord, in addition to notice, your lordship may also grant us liberty to serve copy on the respondent counsel who was before the single judge.
We will show their name only.
Well,
We will show their name.
yes.
These orders.
We will find out from our records and we'll make an endeavor to serve.
Why? In that there is a mention of their name in the infirmed order.
Yes.
na?
Yes, Your Lordship.
Show that the infirmed order, that liar's name. Okay? Tell those liars that they have succeeded in obtaining.
Is in 1-3.
Yes.
Right.
Item 7, date appeal 277 of 2024.
My lord, this is at par with that block grant matter which your lordship have posted for 13. And in this matter, it should be analogously had by that. That is WA number 197 by 2024.
Provided you pay 20 rupees.
Per day. Nominal.
No nominal. We have fixed already. We can't change that way. See, 20 rupees order. Okay?
Within 5 work. Or 2 weeks.
2 weeks we are giving.
Yes, great.
2 weeks. Post immediately after 2 days. 2 weeks. For ascertaining compliance. Okay? There are standard format. Okay.
Item 8, date appeal 28 of 2024.
18 also that covered by that Sarath Parida 197 of 2000.
197. Same order.
8, 9, 9 and 10. That will delay 8, 9 and 10.
8, 9, 10. See how many days. Do you have the
There is an
format of that order?
421,
435, 421,
435 and
714.
714.
Okay. All 2 weeks. And immediately after 2 weeks, they should be posted. That will not be posted. 10 days you pay. Within 10 days you
2
pay.
weeks, my lord. Holiday is there, 2 weeks.
No, that will come after the vacation. For picking small amount, payment within all 10 days. 10 days.
10 days.
Call on the 11th day, which will be date just see. So that we can dismiss that thing on that we don't get sent. We don't make payment. Yes.
Item 11, date appeal 6 of 2025.
मतलब forward and last and that's the lordship.
Have you changed the factors?
Give him one copy. Sorry.
Paragraph 2. Basanti Das. See, correspondingly you have to change. Okay. Dismissed.
Item 12, date appeal 978 of 2025.
What is this matter about?
12, huh? Well, my lord, it is assigned to
6 19 days. 19 days. You know which order? That 20 rupees surgery. 20 rupees.
And within 10 days.
Within 10 days. Post on 11 days. Okay. Your standard format, na? Okay.
Item 30, need appeal 1, 2, 3 approval notification.
Just one.
Not by that one. This is a Basanti.
Lord, the assigned Mr. G can pass it over.
Pass it.
जीवा बसिन के सुना जीवा बसिन की नहीं पता नहीं लगा है तो फाइल तो नहीं फाइल लगा है এটা মোর এটা তো আর না এটা ব্লক এটা দেখো ছবটা ছিল এটা তো মোর এটা ফোন করে দিও না
No, this is also covered by WP 20713 of 2016. Unless you show that order is put in challenge. This Tarsem Singh.
And last 2 days back.
Last 2 days back we have disposed of. Do you have that copy? Do you have copy of that order?
I've got the copy. I can share with you.
Just the subject matter of this. The state is in intra-court appeal for laying a challenge to a learned single judge order dated 13 May 2024, whereby the respondents WPC number 13719 of 2024, having been favored, the following relief has been accorded to him. Next paragraph. The learned single judge has followed the decision of Apex Court in decision of coordinate bench of this court in Swarnalata Sahu versus State of Orissa and others, WPC number 19445 of 2016, and the Apex Court decision in Tarsem Singh versus so and so versus Tarsem Singh, perhaps it is. In other similar matters,
Here, Lord, it is in connection with that Varcha Jample, Naresu Pradhan and Chandranandi.
no,
This is
no,
order dated
no,
2012-2003.
no, Narsem Singh. Tarsem Singh and different matter. It is not. This we have already, similar matter we have already dismissed.
Well, the impugned order at page 27. 27, Lord, impugned order.
20?
No.
No.
This is item number 15.
15.
15. No, I am talking about 13, Lord.
No, 15.
13 has been disposed of, no?
Passover, because you said your friend has to come.
That is also covered. Lord.
That is not so. That we have. That is
13, Lord.
That is not so.
What are the 5, Lord? 13.
13 also.
That Naresu Pradhan and all other things which has
This you
been.
have seen. In view of the above, the appeal being devoid of merits and explanation offered for condoning delay not being plausible
Here, my Lord, delay is 539.
is dismissed. 500 odd days. No, 499 days is dismissed. Dismissed, both on merits and delay. With the reference to implement order of the learned single judge within an outer limit of 8 weeks without driving the respondent employee to avoidable one more legal battle.
8 weeks, no?
Okay.
8 weeks.
8 weeks.
Item number 13.
Item number 13.
That is Basanti number.
Basanti is which serial number? 13.
13.
13, all right. But which one? 11 and 13. Same order. Okay. Both on delay and merits. Okay. Yes? It is over. Which one?
The 69 matter.
That matter has not come, na?
That will come and will be covered. Okay.
Both the matters similar to yesterday's
Do
item.
you have a copy of that order with you?
That copy order.
Yes,
You know
please.
that now? Which is that matter? Tell me.
Item 10, WA number 2659 of 24.
Amresh Behra.
My lord.
Get one copy. 22nd March 2022.
My lord. My lord.
No, one which we decided, now which is that judgment? Yesterday, which we have decided,
Yes, item-
series of matter.
Item.
That-
My lord. 9 of 25.
Okay. Same.
Obliged.
Right.
Both the matters are.
My lord.
Both the matters, na? Delay of how many days? 157 days.
These are the only two that we said about.
Two matters. Okay. Yeah, continue. Go on calling one.
Item 1.
May I please, Your Lordship?
Ah,
Lordship, kindly come to the order dated 20/11/2025.
how many days it was given? 8 weeks.
8 weeks. Yes.
Order was made on?
Order was made on 20/11/2025. And I communicated the same on 25/11/2025, Your Lordship. That is under Annexure 2, page 10, Your Lordship.
And 8 weeks are over on?
8 weeks over on 25/1/2026, Your Lordship.
Police notice. Emergent police notice, fixed particular date. They will come on 3rd July. Why 3rd July? No time, no.
Petitioner is 70 years old, Your Lordship.
Okay. 3rd July. Okay. Careful. Yeah? 1 to 45. No orders 1 to 45, nobody, no order is complied with that.
Lordship, I have instruction of a lot of, right now, my lord, item 15 and 16, they have complained, I will file affidavit, my lord.
Where is that? In 16.
15, 16, my lord, I will file affidavit, my
1
lord.
to
Some
14, police notice. All the 37. Give that 15. Where is the complaints? Positive complaints or negative complaints?
my lord, negative complaints, my lord.
Negative complaint.
Lordship.
Who appears for 15? Santosh Kumar Das. What was the direction? Go to the order.
Lord, direction is, my lord, for consideration of the, Lordship, kindly have a glance to page, my lord.
Representation, consideration.
Lordship, page 10, my lord.
You, Register, are you for complainant? No. This complaint is against non-compliance of order dated.
Lordship. 10, 2025. Page 9, my lord.
2025, entered in complainant WPC number 30382 of 2025. The operative portion of the order that paragraph 4 and the same reads as under. First, at the admission stage, learned DGA, JSC, Mr. Conductor appearing for the Contempt has filed the compliance order number dated 7th May 2026, whereby consideration of the subject representation has been made. And the request of the complainant is rejected. Personally. Next, this court being only a court exercising contempt jurisdiction cannot undertake critical examination of the correctness or otherwise of the said order, subject to all just exceptions. First, in view of the above, the contempt proceedings are dropped with liberty to the complainant to lay challenge to the same, to the rejection order, in accordance with law elsewhere. First, in that connection, all contentions are kept open. I feel that,
Lordship, item 16, my Lordship, kindly one passover I have received in a WhatsApp, my Lord.
Passover. 17 to 45. Any complaints?
Lord, I have been allotted to till 25, my Lord. Till 25, others are not complained, Lordship.
Emergent police notice. Returnable within 2 weeks. Call on 37.
Item 46.
Mala 25 to 27 to 44.
27 to. Kindly do not disturb. Kindly do not disturb. 27 to 44.
I'm sorry, 26 to Mala.
26 to.
So, I'm sorry, Mala, 26, 27 and 28 and 29. These are not state matters. These are some other matters.
So there the contempt will get.
Then till 45, race matters will not. Lordship will grant us one date, we will file necessary affidavit.
Emergent police notice.
Yes, yes.
Petition 255 of 2025.
My Lord, kindly permitted to withdraw.
You want to withdraw?
Yes, ma'am.
Why? You filed it and now you want to withdraw? File a memo.
We have already.
Right? The memo? Yes, memo. Learned counsel for the review petitioner. How judge can work if you do like this? It is not possible to work at all. Has moved a memo seeking leave of the court to withdraw the review petition. First of memo reads as under. Any objection from the other side? No notice is issued. Matter is at the admission stage. Right to file a litigation, right to institute litigation includes right to withdraw the same, subject to all just exceptions. First, in view of the above, the petition is leave having been accorded. Review petition is disposed of as having been withdrawn with no liberty to seek its revival. First off, registry to send a copy of this order to the respondents by speech post immediately. Yes.
Item 46.
Excuse me, I have filed an application for recall of a lordship order.
Recalling the order.
Recalling the order. But
Why?
I have a handwritten note. I have typed it out. Can I produce a lordship? My argument. Give it.
But why were you disturbing the court?
Huh? No.
What no? I saw you.
I'm sorry.
Call this matter up. No, he disturbed. Call this matter of relation. Yes.
Well, I was sitting. I did not.
All right. I have observed you. Whoever has that trouble, we are calling it. I'm not dismissing. Calling it after occasion. Call this after occasion.
I did not utter a word.
Next.
Item 58.
Sorry, on behalf of the bar, Malay.
No,
That's correct. That's correct. Lordship is correct. So, the young advocate is good.
yes, sir. What should happen, Mr. Das, in this matter?
For this matter, Lord, what happened, my lord? He wanted a recall and a review of the matter. After 6 months of disposal of the case, if the IA is not maintainable in clear fee, judgment of the apex court.
You have to file review.
Yes. Recall
To
of
file
the
a recall is not possible unless it is SP Changalavarayan I do.
question. And
If it is SP Changalavarayan I do, recall is possible. Otherwise, we'll give liberty.
Lordship, can listen page 2 of my objection. Fee judgment, that is Uttar Pradesh versus the Brahma Das Sharma and others. Another is Sushat Kumar Rai. And another is my lord Lala Nalin Kumar Rai versus all the judgments said that in fact IA is not maintainable in the disposal of case.
Application in IA number, but it speaks of modification of the order.
Yes.
As an application for
But
modification.
What is that modification?
Your Lordship may kindly see order date 8. Your Lordship may kindly see order date 19/8/2025. Your Lordships. It's a case of regular.
19/8/25.
Yes, it's a case of regulation. Regulation. The petitioner continuing a data entry operates in more than 30 years. More than 30 years, Your Lordships. Your Lordship may kindly see operative portion at paragraph number 4.
Wanted to be regularized. Another cadet was very junior assistant. Lordship said that no.
So kindly read paragraph 4.
Oh, yes. Learned counsel for the petition notifies to the court that the tenure of this client is extended by 1 more year. Lordship order this of themselves. Therefore, the input order now telling to the significant steps have to be taken as to the claim of the regulation. This aspect, yes. So, my lord, in the meantime, he is also allowed to continue till
1 year.
2007.
But what happened to the regularization?
Regulation will take place. In another 2 judgments, so Lordship said that no date of judgment of the read petition also taking state.
No, when are you going to do that?
3 months or so.
3 months. You will regularize your services.
But text state. No,
They will regularize your services. The
that too against that data entry operator. His main prayer is for data entry operator. His original prayer. So regulation against that. That's no problem.
But regulation as per the resolution 79/2013.
that
Yes.
resolution dated
79/2013. But in IAM alerts, I have filed 2 judgments of your Lordships which
That is
cover the entire case.
anyway, they are saying within 3 months they are doing it. Nah?
Yes, yes.
The case is not maintainable. That's why you are giving extension.
No, there is not review. Modification of the order.
Yes.
It's not review. Therefore, those judgments are not applicable. This court, while disposing of the writ petition, observed at 4 as a para 4 of its order dated 19/8/2025 as under. First. Now, an application supported by affidavit is moved seeking modification of the said order, essentially to the effect that there should be a direction for regularization of the petitioner. Correct?
Yes.
In terms of resolution dated 17/9/2013. First one. Learned senior advocate appearing for the advocate on record for the fees.
State Council for Technical Education and Vocational Training.
So very fairly submits that the case of the petitioner would be duly considered in terms of the subject resolution within an outer limit of 3 months. 3 months. Provided that all contentions are kept open. First one. Ordered accordingly and application is disposed of.
Great. You can say.
All right, don't disturb the court.
Ma'am, sorry.
No, don't disturb the court.
Well, I
I
will-
come with lot of pressure, with anxiety to do justice. Yes.
Madam, copy has not been sought on me. They have filed a IA for modification recall. Copy has not sought.
Who has to give, where is the counsel?
Government has filed the modification and recall. And I am for the petitioner, dispose of case.
Application on the learned counsel representing the OPs. First off, put this matter, if such a copy is served and acknowledgement is filed in the registry, and not otherwise. Okay.
3198 of 2025.
Of course, in your lordship, there was a direction for disposal of the case when the case itself is not ready, and that was passed, of course, without the notice to us. We filed a IA. On the last occasion, by
How much time you need now?
But this time,
I am also your lordship was pleased to observe that the land district judge should take steps for serving either substituted service, whatever, to and then some of the respondents, my lord.
Not you.
No, I am there for your lordship. Already I have appeared there also.
Who are those respondents?
My lord, they are in the appeal. Your lordship, annexure 1, page 6. Your lordship will kindly see.
How much time was given for disposal?
Initial order of your lordship,
13/11/2025. Why are they avoiding the service?
No, it is not that way. But in fact, all facts were not brought to your lordship.
That's all right. What we said is dispose of the matter.
That is
Very
I don't have a grievance for disposal also either. I have succeeded in the court, they are in appeal. If the appeal is also disposed of, I will not have a grievance. But the completion of the notice and everything is to be done for hearing of the appeal. That is what
The writ petition was disposed of by order dated
I am
13.
appearing for the petitioner, read petitioner.
Directly. Expeditious disposal of appeal in question. Appeal in RFA number?
RFA number 68 of 2025.
RFA number 31 of 68, na?
31/68.
That is finalized.
I stand corrected. 31/68 of 2020.
31 of 31/68 of 2025.
Yes,
Pending
sir.
third additional and third
Pending on the file of learned third additional
ADJ, additional district judge.
third additional district judge, which
Puri.
place? Puri. First stop. Learned senior advocate appearing for the applicant seeking recall of the said order points out that notices have not been served on the respondents in the said appeal, and therefore
And substitution also not done. Your lordship sees order dated 25/9/2025 by page 8.
first stop.
My lord, in this regard, I want to bring your lordship's notice that a notice has been served. The present IA petitioners, they have entered appearance in that appellate court.
No other respondents.
18th for hearing.
Other respondents are served.
Yes, my lord, all the respondents are.
Learned counsel appearing for the petitioner at this stage submits that already service has been accomplished and matter is ready for hearing and disposal. First stop. Next paragraph. In view of the, how much time was given earlier?
Earlier, your lordship gave 4 weeks. 4 weeks time.
For disposal of the RFA?
I got
Okay.
only because
In view of the above, the application having been partly favored, the learned judge is requested to hear and dispose of the appeal within an outer limit of 3 months. Record from this date. First off, all contentions in that regard are kept open.
And also, I must bring your lordship's notice that your lordship also take that appellate court also sought for time that he had flag some extension of time the court has
This
sought
order
for.
is made after taking note of the request made by the learned judge himself. Okay. All right. Judge also. Next.
She was by order dated 28/11/2025. Stay the order of the transfer for a till academic year, and thereafter I will join me. So in the meantime, what happened, my lord, the present petitioner has engaged in as a census, my lord, census duty, my lord. Further, there is a bar. What's due to this order, my lord? Passed by your lordships, 28/11/2025, man. I have to join in that school, man. I have to join new school.
Yes, we have said no, that only. Where is the requirement of interference?
Man, since
Census duty, that is no ground for you. Census duty is a statutory obligation under section 28 capital A of Representation of People Act 1951. That's your duty. How that is coming to aid, to your aid?
My lord, since my lord, I have engaged in my they are that school who earlier who is in which I were serving my lord, and I have transferred to another school. My lord. I have engaged in the present school, and now due to this order, my lord, I have already joined as per your lordship's direction in the new school. My lord.
You have joined already?
Already. So your lordship may modify that so that I will come to my lord. What happened, my lord? Every day I have to go to that school, join and report to census duty. My lord. That is the problem, my lord. 30 kilometers I am up and down.
You take, you serve a copy of notice on other side. Let us see. Next week. Give that copy. Mr. Panda, what can be done? Just look into this. Yes, give copy. No, call next week. Call next week. If a copy of the application along with all the documents is served by counsel for the petitioner on the learned EGA, Mr. Panda.
In course of
Just now I am.
In course.
Serving that.
No, I am serving well within.
In course of the lordship specify in course of the
In the course of the. Yeah.
I am intervenor OP5 in the read petition filed the IA for variance of the status quo order dated 19/12/2025, my lords.
19/12/25.
Yes, my lords. My lords has passed the order, that status quo order, and if grounds do exist, then for variance of the order, the liberty is granted, my lords. Then I intervene in the matter, my lords, OP number 5, by the order dated 17/2/2026. And also filed this IA for variance.
Objection is filed to the IA.
I am in this petition. I am the opposite part number 4, my lord. And
there is for petitioner.
For the petitioner, my lord. Since my learned senior has filed a application for vacating the.
When it was served on you.
I have filed also objection, my lord. But it needs merit consideration of the matter. Therefore, I some time, my lord, 1 week time may be given for final hearing.
My lord, already time has already been in the coordinate bench. But some
there will be some matter itself we can take up. Immediately after vacation, we will take up the matter.
Yes, my lord.
Because the reconstitution of management has not been reconstituted for last 2 years.
Premature, your lordship.
That is
Premature.
Premature.
That is not on.
No.
That is not under challenge.
My lord, this opinion number 4.
Managing committee is not.
Let me submit.
No, what is your prayer in the petition? Read it.
Subject to some material facts, my lord, so that.
Letter dated 7406 dated 31/10/2025 shall not be set aside. What is that letter? Annexure?
Annexure 6 of the
Annexure 6, my lord. Page 66.
To replace the headmaster.
Yes,
You are the headmaster.
in charge.
You are in charge.
My lord.
block grant schools, my lord. School is a block grant school. My lord, I am 30 management, my lord.
For reconstitution of the MC, what managing committee, what objection you can have? You are only in charge office holder.
Yes, my lord. The outgoing headmaster also in charge. There are
solid. What is your right? In charge. Apex 1991 Supreme Court says.
Without giving any opportunity, they have substituted me.
So what opportunity should be given to you? You are in charge holder.
Yes, my lord. But without any notice. So
why notice should be given to you? You are only in charge holder. You don't have lien to the post. Had you had lien to the post, then question of principles of natural justice will arise. You are in charge principal. Now you are asked to go where? You will be removed from that post.
Yes, ma'am.
Is he going to be removed from the post?
Yes,
no, my lord. No.
You are not removing him.
No.
No, I am not.
Yeah. But what is your objection to the constitution of the new managing committee?
No, my lord. I have no objection with regard to the
yes, my lord. He has objected so that the reconstitution has been altered for this petitioner, my lord. The rule says that I should be the headmaster in charge.
Who
But
are you?
I am a TGT teacher of the institution.
It's a classical teacher.
Classical teacher should not be the headmaster.
Headmaster.
You are a classical teacher.
Yes,
sir.
sir.
In
He cannot
Sanskrit.
be the headmaster.
No, cannot
If
be.
that rule shows.
That as I have given in my annexure,
Which annex?
A series of my IA at flag C. That is at page
I
5.
am not a party to the proceeding.
No, I am not party, but intervene in the matter. And so
We will allow the application for impleadment and call this matter next.
already been implemented.
Yes, sir.
No worry.
Attend, my lord.
Please, please. Yes,
He has been.
I have already been intervened and appeal number 5.
My lord, by next
But,
week I will prepare.
Minus let the see annex of 5 how he has manipulated. Annex of 5 at page 60.
No, you show me. 1 second. You show me. A classical teacher cannot hold the post of
That is
principal on in charge.
annexure A series at page 6, my lord.
Page 6 of.
Yes, my lord.
What is this?
The rule 28E, the headmaster or teacher in charge of headmaster of the school is ex officio capacity. But and the senior most trained graduate teacher of the school should be the headmaster in charge. Well,
Where is that?
that is in the rule 28A that is given this gazette notification as amended in 1994. That is given in my annexure
Annexure?
at page 5 of flag C of my IA 1332 of 2026.
Annexure 5.
Annexure A series at page 5.
Read that you have to show a classical teacher cannot hold the post of principal. Show that.
No, that has been stated that the trained graduate teacher should be the headmaster in charge.
That's all right.
But
Where is that?
That has been at page 6.
Only trained graduate teacher.
Yes, ma'am.
He is not.
He is not. And well, let's let it turn to next the order of the higher authority, my lord, at page 28, my lord. In para 1, page 8. The sanctioned strength of trained graduate teachers in block grant new GIA category high schools, as per government rule, any trained graduate teacher is a senior ACS cadre category irrespective of government aided private schools, remain headmaster in charge of the school. And while in para 2 it has been stated, the other category teacher, so as classical teacher, Hindi teacher, PT of any type of the teacher in the school, in above category
Not
high school,
entitled to.
that will be lower ACS cadre category.
Read further. And
Yes, ma'am. The sanctioned strength of trained graduate teachers in block grant new GIA category schools is 5. As per government rule, any trained graduate teacher is a senior ACS category.
no, not that. Para 2.
Para 2. The other category teacher as classical teacher, Hindi teacher, PT or any type of teacher in position in above category high school are lower ACS cadre category and not entitled to remain in charge of a headmaster in the school.
What do you say, brother? This is the rule.
Yes, my lord. Therefore, I'm
Take down.
taking time. My lord,
My lord,
I am
for the management opposition for my lord. I have filed a writ petition. Also, I have challenged the notification issued by the block education officer.
Misleading my
Yes,
is
yes.
not the president.
I will.
The circulatory has already
My
been
lord,
reviewed.
my lord. My case number is 36387.
Another writ petition. is
Another
there.
writ petition I have.
That
I am
is
the
before
member.
another bitch.
No, my lord, in the same box.
Before me only.
No, this case not attached in this case, my lord. In this case, my lord, I have a resolution was passed, my lord. Yes, my lord.
What we will do is,
Sir.
we'll send both the matters to either this court or to
This
some
court,
other
my lord, this
We
court.
don't know.
No,
You are not Chief Justice of the court. That Chief Justice, Honorable Chief Justice will decide that. It is told at the bar that there is another case in WPC number
36387 of
36387 of
2026
2025 filed by the management of the institution, school, which has got factual contiguity with this writ petition. First of all,
May I interfere, my lord?
therefore, both the cases need to be heard together by one single bench so that there shall be no conflicting views.
Yes.
if any. First topic. Next one. In view of the above, registry to explore the possibility of placing these matters before one single bench after obtaining necessary orders at the hands of Honorable the Chief Justice next week.
My lord, already the Honorable Chief Justice has passed the order, my lord, given consent to have this matter by your lordship. Yes, my lord. That is so. No, not addressing the matter rightly, my lord. Before the order dated 1912.
Let remote the matters come so that
Next week, my lord. That is the minutes consent of the Honorable Chief Justice, the matter to be had by your lordship.
Next.
Interim order to
My lord, on tomorrow, next week.
To continue till next date of meeting.
My lord, next week I stay, my lord.
Yes. Therefore, we said next week.
Yes, ma'am.
Yes.
Contempt is from 8/2025.
I mean, pardon your lordship, people have now decided they have put up these matters and similar matters, your lordship. 65 is also similar to this matter. They put it before the law department in order to see how to comply with it, your lordship. The department has put it before the law department to find ways to comply with the matter, orders of this honorable
You will
court.
comply with the matter.
Yes, your lordship.
Order
Yes, your lordship. They have sought for 6 weeks' time.
for compliance. If they do not comply, it will be aggravated contempt.
Yes, your lordship, because they have
We'll
to
record
consult with the finance and law department, your lordship.
Please listen to the judge first. You don't have to listen to the judge.
yes, my
Post this matter after vacation.
My lord, I'm ready to listen, my lord.
What kind of lawyers here? So don't want to hear the judge also.
Yes, my lord, I'm listening.
Now, madam is saying, this order will be implemented within 6 weeks.
6 weeks, they have referred these matters, similar matter also, item 65, to the law department, your lordship.
No, we are asking you,
Yes, your lordship.
are you going to implement the order?
Your lordship, it has to be implemented because your lordship.
Record that. If you do not implement within 6 weeks, then those who are responsible for implementation shall pay ₹1,000 every day till implementation takes place.
Lordship, they have sought for a time filing. They have instructed us to file a time petition of 6 weeks because they have referred the matter to the law department to look into the matter and to seek that it should be complied with.
Why once High Court says again it should go to the law, his approval is required.
Your
For
lordship, I have the
implementation of
right.
our order. Does he sit in appeal over us? He is not division bench. No, some coercive proceedings have to be taken. You keep your CD secretary.
Some breathing time, your lordship. 6 weeks, your lordship. Let it come after vacation. On
What
the
for?
reopening of the vacation, your lordship.
What for?
In between that, your lordship, we will pursue with the government, your lordship.
Not pursuing. Compliance, if you are sure,
Yes.
will leave. Otherwise, I will summon those people. We are not, citizens are not at the mercy of the government. Government should be at the mercy of the citizens. What are you going to do now? Is there complaints? Let us see.
We have pursued them, your lordship.
No, no,
My
see.
seniors here
What
have
is the
also
order?
pursued them, your lordship.
I know.
This is the
65, 68, 69. Into it out.
Also,
There is a specific direction. Kindly come to page 9. Unless he disturbs you, so that I will give you some more time for studying. He is not now disturbing. Therefore, you have to read now. Read. Come to page 9. Come to the last 5 lines of the order.
Order dated 10 April 26.
On such extension of the benefit of regular appointment, all service rights or so and so, quashing the said order, the OPs are to extend the benefit of regular appointment in favor of the petitioner from the initial date of appointment.
Yes, Your Lordship.
What is there to be consulted? Who is to be consulted for implementation? Simple implementation. You will send it to law secretary will send it to chief secretary to the attorney general to the law minister. You cannot go on that way. Orders have to be complied with. When are you going to comply with the order? Whom we should call for a personal appearance? We'll direct personal appearance of your secretary. Against whom order is there?
So let's permit your Lordship kindly see the order dated 10 April 26 passed in contempt petition by
26.
10th April 26.
10/4/26. Go to
By passed in contempt petition. Complaint alleged non-compliance of the order dated 28 by passing in deed application number 28659/24. After service of notice, the contempt have entered appearance to
No, already there is a direction for payment of 5,000 rupees.
That's what I'm saying.
That also is not paid.
No.
The operative portion of the order whose violation is complained of reads as at. Last but one paragraph. Next point. The notice, police notice. Police notice was the police notice was served on the contemners. On which date they were served?
On
Tirumala Naik IAS.
26 it was issued, Your Lordship.
Huh?
On 4
Police notice was issued on
4/2/26.
4/2/2026 with a caution warning. First off, the said order reads as under. Next paragraph. On 20 February 2026, from this term, February. The following order was passed and an adjournment was granted, obviously for compliance. Compliance is not done. On 13/3/2026, this court threatened the contemner with possible arrest and detention, and compliance is not done. He is not deterred. On 10/4/2020, on 10/4/2026, the following order was made. Next paragraph. The contemner appears to be thick-skinned, and therefore an extraordinary order has to be passed. First, not complying with the orders of the court is a serious matter, because that would shake the rule of law on which the state is founded, the administration is founded. First, rule of law is held to be one of the basic features of the Constitution of India, while Keswananda Bharati was the state of Kerala, 73. Next paragraph. In the above circumstances, the Director General of Police is hereby directed to arrest the Commissioner cum Secretary, Dr. N. Tirumala Nayak, IAS, produce him before the law.
Due apology, my lord. Let's make this matter next week. And say that the order is complied.
No, where is the respect? Your Tirumala, who is this Tirumala? Let him go to Tirumala, not here.
My lord.
What kind of fellow he is?
Lordship may call this matter
What for?
next week.
What for?
For compliance.
No, even when we threaten arrest and detention, he does not care you.
My lord, probably this must not have brought to his notice.
No,
Let's
see,
bring it direct.
twice we have given time. We have threatened him, arrest and detention. He does not care us.
My lord, one lordship may.
No, he should be arrested.
My lord, he should be arrested.
Arrested and put into some room in the court. Because if we send him jail, he will have facility.
My lord.
No.
My lord, lordship will pass that order in the next week.
Next week, your lordship. 1 week time. We'll pursue.
No, we will pass this arrest and detention.
My lord,
he will be brought before the court.
My lord. Lordship
Ask him to come before the court at 2:30. You ask him to come before the court at 2:30. What these IAS officers are thinking?
Lordship,
Do they think that they are babus?
my lord, definitely he will come.
No, we will cut them short. We will cut them short. That is not the way the IAS officers, a section of the IAS officers, are ill-treating the citizens of the state. We have been seeing. See the kind of orders we have. I have written the orders with a pen dipped in acid. And he does not care us.
Lordship may call this matter next week.
No, call him at 2:30. Call him at 2:30. Otherwise, I will directly Director General of Police to arrest him immediately. Wherever he is, he should be arrested immediately.
My lord, next week.
Ask him.
Lordship may call this matter Monday.
Monday,
Let him stand here. Let him face. Let our bar member see his face.
My lord, lordship may
What he thinks.
on the Monday.
On Monday, your lordship will be mentioned.
Full stop. At this stage, learned AGA Mr. G and Madam made a very humble request to have this matter on Monday, and therefore, and to keep the decision to arrest and detain him. First off, very reluctantly call this matter on Monday.
Item.
No, I will not. Any other matters are there where he is involved?
Item 65, your
He
lordship.
is the same secretary.
Same content.
69.
Why such secretary is retained in our department?
In the
We'll
department.
write for his removal.
My lord, in the
You
department.
send him it to some other substandard post.
In the Department of School and Mass Education, number of contempt applications are there.
No, against him, how many matters are there?
You know, all the.
How many, any
Item 65, 68, 69.
73.
Apart from these two matters, another two matters, 68 and 69 also there.
65, 68, 69.
Let it on Monday.
Actually, we don't call your officers to court because court is a sanctified place. We don't want them to be here. Okay? And they're represented. But if he does like this, then we know how to treat.
My lord, lord.
So just ask him to see our today's video. Okay? It is online. People of a state का लोग वो सबको एक बार बोलना चाहिए कि IAS ऑफिसर वो बाबू नहीं, वो हमारा बाबू नहीं, और हमारा ईस्ट इंडिया कंपनी सरकार नहीं, लेकिन संविधान पर सरकार जाता है, लेकिन ये सब लोग वो नागरिकों को बहुत परेशान कर रहे हैं. I am speaking in my bad Hindi, so that let people see them. This is too much.
My lord, I'll
On Monday at 10:30.
Item number 65, 68, 69 also. The same.
Same order. Same order. Call this matter. On Monday, Mr. G, on Monday for reporting compliance.
Yes.
Otherwise, he will be personally present before the court. Call on Monday for reporting compliance, failing which he runs arrest and detention at the hands of Director General and Inspector General of Police. First off, a copy of this order should be, advance copy of this order should be sent to the registry shall, Registrar General of Court shall send a copy of this order to the Director General and Inspector. What is the post in your highest police officer in your state?
Director General and Inspector General of Police.
General of Police, Bhubaneswar.
No, my lord.
Orissa.
Cuttack, Cuttack. Cuttack, my lord, itself in Cuttack.
In alert position. Okay. Contact.
That one copy be supplied by the at the earliest
Of this
communication.
order shall be shared with the learned DGA.
Pleasure, Your Lordship.
What the people are thinking. Jawaharlal Nehru, Pandit Nehru writes in his autobiography and in his discovery of India that ICS he was speaking about. ICS people are neither Indian nor civil. He had written that sentence appears. That appears to be true even after 75 years. Yes.
This is an aggravated contempt. The government has decided to comply with the order, Your Lordship, and has.
What is the compliance? Positive compliance or negative
Your Lordship.
compliance?
No, but I have given a document.
Yes. Decide to comply with the order of the High Court. Past in the decide to complying is one thing, compliance is another.
Yes, Lordship, they have said that you are therefore requested to take necessary follow-up action in the matter and report compliance.
When this order is passed?
This order is passed on
Yes.
4/5.
4/5.
4/5.
After court notice.
Your Lordship.
It must be. Otherwise, see, they refer to contempt case. They don't do on their own. Somebody has to hold chabka with them. Otherwise, they will not do. No, decide to comply. It means when are you complying?
Your Lordship may give us 3 weeks' time, Your Lordship.
3 weeks.
3 weeks.
How much time was given in the order?
There was judgment and 10-4 order by Kaisi. 10-4-26 order.
Then for 26.
Yes, last order when the contempt was dropped. This contempt was dropped because of their submission. Order number 5. Learned AGA submits, shall I read, madam?
No, see, additional secretary sends a letter to additional secretary. From additional secretary to additional secretary or DO.
DO, Your Lordship.
Why DO has not complied with the order?
Lordship, this is the instruction that we received. If it next week, let it come, we'll see compliance, Your Lordship.
May
Monday.
one minute, ma'am. Monday, like I have one document I have filed along with my affidavit, yesterday's affidavit, that is communicated to me, addressed to the learned Advocate General. There they say already they have violated my lord's order. They have, a retired employee, 2,12,681 has already been recovered despite the judgment of this Hon'Ble Court. This is the order I have annexed. And today he is saying we will comply. Is it a compliance?
Monday we will.
Monday.
Call on Monday. Who is that DO?
DO Bhubaneswar, Your Lordship.
Who is the contemner?
The contemner is the secretary, controller of accounts, and the DO is the lower rank officer. And the controller of accounts has withdrawn the money. All the three were the contemners. Secretary says, if my lord
again, Thirumal Naik.
Yes, same person.
But notorious.
Secretary School and Master. The retired lady, the retired employee. Everything has been.
Call this matter on Monday. So contempt court will sit 2 days hereafter. Monday, Friday. Yeah. Monday for reporting compliance. Failing which stringent action follows. Yes.
My pleasure, Lord.
Yes.
Okay, this question, what has happened, the judgment was passed at the stage of admission. No counter was filed. Therefore, there was some mistake of facts. I filed an interim application for recall of the order. Your Lordship had annexed, your Lordship had annexed to please to dispose of the interim application granting liberty to file review application. So therefore, this review application has been filed for the
Where you have given the liberty?
Liberty by the annexed to your Lordship machine.
Annexed to?
Yes, miss.
To seek review of the order.
Yes, Mayor. Page.
We'll call this matter after vacation. Let him look into it and come back with your objection. Right? Let him file objection to review petition.
28 days delay, Your Lordship may condone the delay because why the
28 days.
But your lordship, notice has made sufficient. He did not file any counter. Thereafter, this is identical matter, copy was sought to him in advance. Then when matter was
You say all this in your objection statement, so that I will reflect. Okay. The review petition is moved with a short delay of how many days? How many days?
28 days.
28 days.
And second one is 30 days, the connected matter. I'm the reviewer.
And 30 days respectively. First up. Two separate applications are moved in IA number 126 of 26 and 127 of 2026. In each of the review petitions. First up. Plausible explanation is offered and delay is also short. First up. In view of that, applications are allowed and delay is controlled. Call this matter immediately after vacation. First up. In the meanwhile, it is open to the writ petitioner to file these objections, if any, to the review petitions. After serving copy thereof, the review petition.
I've already shot. Copy already shot.
No, objection to be served on.
Yes.
Next.
in the review, your lordship, in the review, I also tendered my appearance.
Yes, and he appears for such issue notice. Appears for such. First line. 55.
55, your lordship, the treasury has also reported compliance.
Complaints reporting.
Yes, your lordship.
Whether money has gone to account of the party.
Yes, your lordship.
Or only to the treasury.
The district treasury office, Bhadrak, has also compliance has been received, your lordship, by the registry also.
It is sent to, money is sent to him.
Yes, your lordship.
All right. If it is not true, then you file a contempt and aggravated contempt. Okay. The complaint is as to non-compliance of the order dated so and so, entered in complainant's WPC number so and so.
There is an interim order, madam.
They've written to the
interim order passed by 11/12.
Interim order dated
11/12/2025.
22 in a pending in a complainant's pending WPC number.
WPC number 35162 of 2025.
Your lordship, as per the treasury letter dated 5/3/2026, it has been communicated that we have made the commutation deduction stop with effect from 6/3/2026, your lordship.
6/3/2026.
Yes, your lordship.
But whatever recovery is earlier, but when the order was made, interim order was made?
11/12/2025.
11/12. But where is the compliance?
11/12.
11/12/2025.
Yes, your lordship.
If that is so, you have to retrace the step. Now you have done with effect from 1/3.
Yes, your 6/3/2026.
Now what about 3 months? No compliance. They think they are lords of Orissa. Call on Monday. For due compliance of the order in letter and spirit, in as much as the order is dated 11/12/2025, whereas compliance with prospective effect is done on 6/3/2026. There is no compliance. Yes.
1051
And matter relates to university minority friend appears may be taken up along with minors, sir, 92 minors.
92
minors. All these cases are similar. They are minors directed retrospective, the regularization or not from the date of their joining. Then minors
along with 92, which date you have? Which
2 days,
today only.
2 days least.
What is the position? Let us see 56. What was the order?
Your lordship may kindly
Succeeds certiorari.
Was dated 10/9/2025. Operating
To pick 5/12/87 as the date of regularization. petitioner shall be given notional benefit of retrospective regularization and monetary benefits only with effect from 21/12/2020.
Only that part.
To that effect, Your Lordship may kindly turn to my compliance affidavit, page 4.
Now let us see what is meant by this order. Let us see whether how your clients have understood. You tell what is meant by this order.
They are to be regularized as Your Lordship said.
Number one, regularize with retrospective effect
My Lords.
plus monetary benefits.
My Lords.
Whether monetary benefits are
Notional fixation, Your Lordship.
for that particular period.
Period.
Then from a particular other period, monetary benefit has to be.
That has been stated in that order of compliance, that compliance affidavit I have stated. I
Have
have
filed the money.
No, the money, that money part, as regards the current salary, etc., that is, that
We are not on that. Whether, therefore we asked you to read the order. Read the order. The operative portion of the order, I take extraordinary caution to make it intelligible to matriculation failed candidate. Because standard of many officers is below that. So therefore, in reasoning part, we use Latin, this, that, etc. In operative portion, plain English of Wren and Martin of high school grammar. Nothing beyond that. Because they will say we have not understood the order. Kindly read the order.
Malins. The operative part, in the above circumstances, this petition succeeds. A writ of certiorari is issues quashing the impugned order dated 6/2/2014 to the extent it fixes petitioner's effective date of regulation as 18/3/2011, coupled with direction to fix 5/12/87 as date of his regulation. Further, the petitioner shall be given a notional benefit of retrospective regulation till 2012-2022 and the monetary benefits only with effect from 21/12/2022.
How much it will be?
That quantification has been done. It's in process and is being sent to the government. That particular answer to your query, I don't have at present. But however, I'll draw your Lordship's kind attention to the next part of the order. So far as financial aspects are concerned, it hardly needs to be stated that opposite party number 4, which happens to be the state government, has to make appropriate budgetary allocation in this regard, compliance within 3 weeks, etc. So that, to that effect, what I would like to place before your Lordship, as regards this budgetary allocation, etc., there has been a communication, a series of communication as regards that. The current salary, etc., as fixed as per your Lordship's order, is being paid to them this month. And but that budgetary allocation as regards, because there are 87 candidates in total, 92 items.
Why can't you read a standard book on budgetary economics? How budget is done? Tell me. Any standard book by Musgrave.
No.
Budgetary allocation happens after the university, whatever money it has in its popular, it pays to the citizen. Then the government will give it. For other things, it is for future. For educational institutions, it is not like that. Do you have money in your bank account or not? State it first.
May I submit my Lord's one line? Say, I am standing in the similar footing. I complied my Lord's order.
Have you made the payment?
No,
Don't say comply.
So, I'm coming. Kindly.
No, have you means compliance means what?
Kindly call one.
Regularization. With only notional.
Now that process is going on.
Other part, payment has to be made.
That is exactly my Lord.
They are all poor people. They are all poor people. They are not vice chancellors and the registrars and other officers of the university. They are all poor people.
That exactly my Lord. I advise them. Now
that advice, our order only don't give.
That order, my Lord, may I submit one thing. My Lord, kindly bear with 1 minute, my Lord. This letter, my learned friend, that letter, my Lord, have given in respect of 10 persons. I have specifically, the university stated about the conditions my Lord fixed. The thing is, my Lord, university will pay all total amount that is stated already.
process is going on within 3 weeks. They will quantify the total amount. They will place this. Pendency of that in whatever balance account available in the university balance, because it is there in crunch of money. What they can share be 86 or 87%.
You show your bank statement to the court in a sealed cover.
Means
you said there is monetary crunch. That will not help you.
no, that exactly.
It's your
Exactly.
passbook.
That exactly. I will produce that exactly. My humble contention is that in this case, we have categorically stated we will pay it from our account.
When?
But I have taken prayer for 3 weeks time.
Huh?
3 weeks time we prayed.
You
In the order
will
itself.
appeal against these things.
No. But the university does not.
Not fair.
Will not be put.
When then now why it is not then till that payment is made to them. Let your registrar not draw his salary.
Because within 3 weeks will complete minors.
No, very well. We believe you.
That is exactly
That
is exactly means we reflected also in the order.
No, we are telling your registrar, your university vice chancellor should know they live in glass houses. Never they have roamed in Bakshi Bazaar.
Once new vice chancellor come just
Therefore,
joined.
he will never know.
Once the new vice chancellor joined just recently, minus 2 weeks before.
Okay.
Once
Since how long registrar is there?
register is there much for 8-9 months. That is not the point, man.
Let him roam in Bakshi Bazaar.
Yes,
I go to Bakshi Bazaar in disguise to know what people speak about lawyers, judges. Yes.
My humble request, kindly consider.
We agree, but till then, he is not supposed to draw his salary.
Without insisting, minors, I undertake minors that amount minors, whatever their minors on calculation, notional basis, whatever minors directed. Well, kind of last time, the university later I've been told.
It's an assurance.
No. You said that it should be paid. Thereafter, we will demand the money from the government.
All right. But you pay that now.
That is process of quantification is going on within 3 months, within 3 weeks.
What is
notional calculations will be there. They are
when this order was when this order was
passed on, that time is over. That already the time.
When it was made?
8/9/2025.
8/9/25.
25.
8/9/25. What was the period given to you?
3 months time or 3 months.
3 months. That will be 7/12/25.
Well, there is admittedly a delay. That is what I beg unconditional apology.
That will not help him. He wants money.
No, money we pay minors.
When?
Within 2 weeks.
Why it was not paid all these days?
Well, that means we are in the process of quantification.
Next should not draw the salary. I will direct the government not to pay his salary till order is complied with. They should know the difficulty of common man.
But we understand, minors. Kindly bear with us, minors. Kindly believe us. At least allow 3 weeks time that whatever stated, so that things should be complied with. We said that it should be paid from the account of the university. Then we will raise that super budgetary allocation is concerned.
We will you are for the complainant. We will record his assurance now. We will drop the proceedings. In the event they do not pay, move an application, then see what
it will be reasonable. Exactly, that is what we have stated.
Which are other matters?
Other matters are in 92 serial, all batch.
One of my affidavit, my 6 affidavits I filed. One of my matters
you will not look at all. You have to make the payment. Simple.
No, payment that is there. We have stated there.
Operative portion of the order dated 10/9/2025 entered in complainants WPC number 23919 of 2023 reads as under. First off, it is in a plain English, and even a non-matriculate can understand. First off, fortunately, there is no dispute as to what the order means. First off. However, that order has not been complied with for in letter and spirit. Although a partial compliance is reported. First off, partial compliance is no compliance. Hardly needs to be stated. Next paragraph. Next, in the learned senior advocate appearing for the university for the contemners. Who are the contemners?
The registrar and the vice chancellor. And government also, but the registrar and vice chancellor
submits that the payment part of the order needs to be complied with, and that it would be complied with within an outer limit of 3 weeks from this day.
Thereafter, we'll raise, we'll stated that. Thereafter, we'll raise our.
For making this payment, the allocation of funds from the state shall not be negated, and the payment shall be made from the bank accounts of the university, or else by pledging their goods or mortgaging their property in accordance with law. First off, in the above circumstances, these proceedings are dropped with liberty to the complainants to seek revival of the same by moving a simple memo. Should assurance of compliance fail, in which event the registrar and the vice chancellor and the registrar of the university run the risk of hauled up for contempt, of being hauled up for contempt. First up, it is made clear that till payment part is complied with, as has been assured now, both the registrar and the vice chancellor shall not draw their salaries.
That part minors kindly be.
No.
That part minors.
No.
Kindly be.
Otherwise, we have to spend time only in contempt matter.
No minors.
All other matters.
Must kindly
be complying with. Why are you worried?
So kindly believe me, my lord.
I believe you.
That is exactly my
believe the court.
Exactly, my lord. Thing is that whatever my lord says, we'll make them conscious.
No, sir.
We'll make them conscious, my lord. Kindly be.
We make payment.
We are.
We get the salary.
We are bound to pay. We will pay.
Sir, I tell you, you have seen the type of government officials we have.
Well, that correct.
We have the type of registrars and the vice chancellors of. Do you have law course in your university? Law course.
Law courses.
Why should not they sit in the last class and take the lessons from some teacher? Whether Contempt of Courts Act is in the syllabus.
With due humility, no, that is not. But that is being
tough. I'm asking you seriously. Otherwise, I direct include Contempt of Court also in
that is being
syllabus.
Because I was the student of that university, my LLM student of that university. Contempt is not there, but these are all taught in judicial process.
I
renew my.
No, sir.
I renew my plus.
The finding of learned senior advocate appearing for the contenders to remove the last sentence is rejected. Yes.
My lord, I may be allowed to pass on my names where I appear for other gainful purposes.
All over me. That is serial number?
That is.
No, they should not. See, we have to invent new techniques for compliance of our order. We cannot have the army here. So the only thing is salary should not be given. Nobody should be allowed. They should not be allowed to enter the office. Next level, it's not now. Next level, such orders will come.
Another thing is, on release of that amount, but this condition will not apply.
In the event, it is obvious that in the event the payment is made to the poor employees in terms of the order whose violation is complained of, there would be no difficulty for the contenders to draw their regular salary in accordance with law. That's the only 92. Otherwise, nobody will care us.
So, for 92 is concerned, all these cases are covered, my lords.
Same order.
Sure, all. We have already passed one order, regularizing them.
92.
We're giving the names. We're giving
same order. Same order. Everything. Give your name. Oh, we want some research from lawyers to ensure compliance. What all court can do, apart from arresting detention. That will be very extreme. Because if they are arrested, there will be none to handle the office. So that creates other problems. Therefore, make some research during this vacation period and tell us what all the techniques we can use, which other countries, perhaps other countries are not this bad. They will comply with the court orders. Anyway, next.
Then when we filed a show cause affidavit, your lordship,
Dated 2026. The first contest they have
What is the order?
order
Your
dated
lordship,
February 2026.
we have filed a show cause affidavit, your lordship, annexing all the letters that we've written to the government, your lordship, by awaiting the sanction of the government to appoint, your lordship. Because we appoint after the government has authorized us to appoint, your lordship.
When was the order made?
The order was made
Was it 10/10/2025?
10/10/2025, your lordship.
Thereafter, first contest was filed.
Lordship, we see the last.
Number 204 of 2026.
10/10/25.
Yes, 10.
Go to 10/10/25.
Annexure 1 in my content list. Operating parties together. Page 10.
Consider the petitioner for engagement as physical education instructor. Even consider, even that also is not compliant.
Your lordship, they have written to the secretary school and mass. The collector has written to this secretary school and mass, your lordship, for sanctioning to observe person, your lordship. That letter is your lordship.
No, we don't want your letter, your communication. What we should do with that order compliance. I am appointed to ensure compliance of my order.
Your lordship, 4 weeks time may be given.
What for?
4 weeks time.
What for?
Because until and unless the government sanctions, your lordship, the collector cannot on his own appoint.
The party to this proceeding.
Yes, sir.
Yes, government was also a party to the
Yes, your
proceeding.
lordship. Yes, your lordship.
Who are the contemners now?
Collector and a DTD education officer. Bhadrak. Bhadrak and a DTD education officer.
Whom direction is given?
Two or three. Collector and the
Collector, but until and unless the collector gets a sanction from the second.
No, that sanction will not come. That's the problem. That sanction will not come.
Your lordship, we written 4 weeks time, your lordship, so that we can communicate to the court the order of the government, your lordship.
Last working 22nd.
22nd.
We'll call this matter on 22nd.
Okay.
If you want to do it, otherwise we will do whatever we want to. Yeah. At the request of learned GA, matter is reluctantly adjourned to 22nd. 22nd. Instantly. Hopefully, the order in question shall be complied with in the meanwhile. Okay. Next date, we will not allow the collector to try his salary. Yes.
58.
Yes.
Sir, I would like to explain in brief the previous event of this case. Sir, 2 or 3 lines. The petitioner was terminated from service in 2015, and the termination order was challenged in
No notice was issued as it. Notice is not issued.
Notice
was issued. When?
I tell you the previous case, 15,477.
No, we are not concerned with
and
that.
by which order? The sub-collector conducted the hearing and issued to termination letter.
We'll hear this matter immediately after vacation. Now we are in urgency. Your matter is serious. It requires application of mind.
Sir, that is serious. I come from 100 kilometers.
We will fix you. Some date we will give you. That day he come here.
Sir, serial number.
Next time when he comes, you offer,
last bus
you offer a cup of tea.
Sir, I can go by last bus.
Okay. Last week, when do you want?
And they are saying if at all a date is fixed and matter is in the upper level, by that he can get a chance and return back to the
post this matter on the within serial number 1 to 10 on which is all right, on 24/6.
24/6.
It will come in the upper part of the card list.
Sir.
So that evening you can go by bus.
Sir.
24th. How many matters are there?
Question.
This is another matter. Then it has to be 3rd July. 3rd July. 10th July, brother. 10th July. Because on that day, that 26th is Friday. I am only on Friday, I come here. Single. Okay? Give that date.
Sir.
Yes. See in the upper part of the list. Yes, sir.
59, Regularization 2025.
Who? It is allotted to me. And for the opposite. Your friend is not here. First of provocation to enable counsel for the petitioner to come and argue. First of presence of counsel for the OP is noted. First.
Your Lordship, I beg your apologies, Your Lordship. The file has been misplaced. Next week, Your Lordship.
Immediately after vacation?
Yes, Your Lordship.
No. Immediately after vacation at the request of the court.
In the meantime, I'll resign. If any, I'll file the resign.
No, file. I will not say. Yes.
May I please, Your Lordship? Item number 61. My Lord, this is a matter relates to the appointment of guest faculty lecturer.
Show cause not received. WPC number signs of pending case. Service has not happened. Service has not happened. Why? Return notice through police it is issued.
Emergent police notice has been issued on 20th February 2026.
Why the police are not
with a question mark that
emergent
judicial superintendent police shall corporately serve or cause to be served the court process and file complaints report through official email.
20 February 2026 had said as and that. First of all, the police appear to have failed to serve the notice in terms of the order. First of all, therefore, inspector of jurisdictional police station is directed to personally appear on the next date of hearing for offering explanation. First of all, however, personal appearance shall be dispensed with if in the meanwhile service is effected and report is filed with the registrar. But registrar to send a copy of this order to the jurisdictional superintendent of police. You put it instead of inspector of police, put superintendent of police.
DCP Bhuvaneshwar.
DCP Bhuvaneshwar?
Yes, my lord.
DCP Bhuvaneshwar. Okay. The registry to send a copy of this order by speed post and by email to the office of the deputy DCP for compliance. First, next. Next.
My lord, can it be posted on Monday, my lord?
Monday in July.
No, my lord.
Next.
This month. My lord, sorry, my lord, it is my humble prayer, my lord. It is my humble prayer, my lord. Kindly.
Yes, sir.
62, Your Lordship, we have already complied. We have ordered for an audit of that college, Your Lordship. We filed a show cause notice, Your Lordship.
The stipulated time period was on 33, was over on 13/3/2026.
What is the order? Positive compliance or negative compliance?
Your Lordship, we filed a compliance affidavit, a show cause affidavit, Your Lordship, where the office of the sub-collector has written to the district local
audit of the school in question.
Yes.
Accomplishment preferably within an outer limit of 4 months.
Yes, Your Lordship.
Whether auditing is done?
That I will Lordship seek instructions. He's already given it for audit to audit, Your Lordship. Given the
auditing has been done.
That I will seek instructions.
All this matter on
Next week, Your Lordship.
Some day next week, not possible because we go. Call this matter at the request of learned AG on 3rd July. First off, non-compliance will be viewed very seriously and cost of thousands of rupees may be levied on the hearing officials. Yes.
Item 63. Percent 5/47/2025.
Yes.
63 miles with deferred appeal. Honorable panels of this matter was listed, Honorable Division with Honorable Chief Justice directed to serve copy is served. Objects were to file objection limitation. And yesterday it could not be seen. Thereafter it could not be listed twice. Once listed, couldn't reach. That's what we requested before the Honorable Chief Justice yesterday. Minors of fixed the matter on Monday.
Monday. Matter is posted on Monday.
Will be posted, man. So a memo or jalapin allowed.
Allowed. Learned senior advocate.
I'm not sure whether it will reach or not, but any minors.
Contemptor submits that the orders whose violation is complained of are put in writ appeal, and a memo is moved before the appellate court for getting the same posted on a post haste. First, in view of that, call this matter on 3/7.
There's 96 also separate.
Same. 96 also. Right. All right.
Item 64. Contempt 6/2025.
My lord, appearing for the opposite party here. On 13/3/2026, your lordship please allow to grant me 2 months time to comply with the order.
Yes.
But I'm embarrassed to make a prayer for further 2 weeks time because I don't want to speak all this technical.
What was the order? Let us see. What was
the order was to present the conveyance with regard to that LIC allotment of flat matter. Correct. But I have instructed my officers that doing it. Little technical snag, I do not want to tell it to your lordship. That's within our office.
No, this order was made last when it was made?
It was on 13th of March 26.
13/3/26.
Right. I only need 2 more weeks time, Lord, whatever kindly give us only 2 more.
No, what is the reason? Why 2?
The reason is not, in fact, I can show it the letter.
No, that letter will not help us.
That
What was the difficulty in executing?
Yes.
That
The
is the point.
difficulty is our property, in fact, lies in Mauja Jadevia. That our deed, in fact, shows the incorrect Mauja, that is Chandrasekhar. We wanted to correct that first in order to avoid any difficult dualities. So for that purpose, we presented a correction deed before the sub-register, referring you to your lordship's order also.
You have submitted the correction deed on which date?
That is 16th of April 26.
Up to 16th, what did you do?
Well, in fact, kindly see, we presented it. Kindly see, we have referred to your lordship's order also.
No.
Can I show it to me?
Wait, when you were supposed to? There was 13/3/26.
Yes, Lord, by 2 months thereafter. Kindly see. Your lordship posted it to 8/5. Within that period, I was supposed to present the conveyance. In order to avoid this difficulty to the allottee, we wanted to make a corrected deed, proper deed, so that Mauja requires a correction. We applied the sub-register referring to your office order that please allow this correction. Now that's a matter which is going on, Lord.
No, it will go on like that. That will not.
My lord, may only see after your lordship's order what they have given to me, my lord.
What they have given?
My lord, they have made a communication that the deposit, your lordship may see the last line, as the matter is sub judice, the realization of the amount shall be subject to outcome of the writ appeal filed in Hon'Ble High Court of Orissa. Instead,
If they have filed writ appeal.
No, because my lord, the order direction was to execute a conveyance. Instead of doing that, they said that the realization is subject to.
No. Your lordship directed to deposit some amount. That amount he deposited, we accepted it subject to outcome of the writ appeal. That is all we have said.
My lord, that's fine. But my lord, in the meantime, your lordship has said that I was only pointing out that time is.
We're not going away, my lord. 2 weeks time, lordship.
No, why it should be granted in the questions? We can't give the time just for asking.
Only for the purpose of correction of that correct Mauja.
When he is drawing his salary, the person who has to execute the conveyance. Ask him, who is he? We'll not grant time that way.
I leave it to lordship. I leave it to lordship. I definitely not start on the way of compliance.
When he is drawing his salary, when
he is a person.
Ask him. He will not draw the salary till this happens.
Jayad Ali Khan. He has shown. We have also shown an affidavit.
No, that's
but instead of this coercive action, as a last chance.
No, as a last chance. Mr. Rathod, we have.
But I appreciate. I appreciate.
We know. They will not do unless Chamka.
If they do not do it within 2 weeks, my lord, I will not come to defend them.
No, if you do it, no problem. Then no, you are giving assurance. Within 2 weeks, it is being
kindly have.
Till then, he will not draw the salary.
Lord, 2 weeks period,
learned senior advocate appearing for the contemners on instructions of his counsel on record, fairly submits that within an outer limit of 2 weeks, the subject conveyance shall be executed and duly registered.
Shall be
Presented for registration in the jurisdictional office of the sub-registrar. And formalities would be completed on a work footing. First up, the same is accepted, subject to the condition that till presentation of the document for registration takes place, the officer concerned, namely, what is his name?
Zayed Ali Khan.
Zayed Ali Khan. Deputy, what is his designation?
Deputy Chief Engineer.
Deputy Chief Engineer, Mr. Zayed Ali Khan, shall not draw his salary.
Deputy Chief Engineer in charge.
Shall not draw his salary or emoluments, even in a route.
Lord, may I just say one more sentence, Lord?
Yes.
That sub-register, your Lordship may say concerned sub-register, because there are 2 sub-registers.
Jurisdictional sub-register.
Jurisdictional. Sorry. I am grateful.
We have said the jurisdictional office of the sub-registrar.
Lord, I know you.
There already.
I know, Lord.
No, in contempt, we are not, we are very, very strict. In rest of the things, we are like surgeons.
Yes.
In contempt, we are butchers. Yes.
In contempt, your Lordship, sir.
No question of, there should not be one single case of contempt.
Yes.
Yes. We are spending a lot of time in this, with all playing with these officers. Yes.
I have filed contempt also. But
We are dropping this proceeding with the above observations. The proceedings are dropped with liberty to the complainant to seek its revival if need arises.
Okay. May I please, my lord? In this case, my lord, the order under review was passed based on my concession, my lord. Unfortunately, on a misconception that ad hoc or contractual employee cannot be replaced by another set of contractual employee till a regular appointment is made. In this case, there is no regular appointment is going to be made because it is purely a contractual post under the self-financing scheme, and there is no regular department also. There is no sanction post. So, and after the period is over, and there are 3 High Court decisions, including a Supreme Court decision, which runs to the contrary, including one of our coordinate bench, my lord, that this is not an absolute rule, and the guest faculty appointed on the schematic post have no right to ask for
Regularization.
They're not regulation they paid for, but not to continue without having an interview also. But there is an interview to be fixed. That was also they did not take up. So what I suggest, my lord, subject to your lordship acceptance, either this may be modified or recalled made for final hearing, or may be modified to the extent that the academic session is going to be over next month, my lord. July, we are going to take out an advertisement for the next academic session. Let them take part in the interview, and preference will be given for their experience.
But
that is not the case, my lord. My senior is taking.
He says by mistake he made
No,
something.
that is not. Yes, I'm just placing facts. But
then we will hear this matter.
No, just would take one line only. I will say I will not take much more time. My case was we are guest faculties. What they have done, they were continuing for 4 years. 3 persons were there before my lord, or 3 cases. What they have done, instead of allowing us, unlike the 4-5 years how they are allowing us, they have issued an advertisement. At that juncture, we came. That for this self-same reason, another guest faculty will be appointed. Why not we will be allowed to continue?
No, he's saying.
What he says is, only in the case of the judgment of one guest faculty or one contractual employee cannot be replaced by another contractual employee, the law laid down by my lords, is only applicable to the post when that is going to be filled up on regular basis. But here my case is squarely covered for the reason one guest faculty is now going to be replaced by another guest faculty. The ratio is not the same. Yes, that is the advertisement. Yes.
What Mr. Das is saying is true.
Sorry, my lord.
Mr. Das said something now.
Yeah.
Did you hear?
That is, my lord, with regard to an interview, there has to be subject to an interview. What I am suggesting, my lord, because they did not take part in the interview. After the period, it was a contractual appointment for a period, particular period. That period is over. They did not take part.
Again, interview.
Interview for the fresh interview is there.
Every time.
Every time, my lord. That's
that cannot.
That is, and they will take, because there are other new hands will be taken.
Why?
Because
They are there already.
What I am saying, my lord, this coordinate bench, my lord, of this honorable court said they cannot continue forever.
No, we are not saying that. It is not that you don't want to continue them. You are asking them to undergo interview.
Yes, my lord. That's
Bench did not say about that. Coordinate bench did not say.
Yes. Your lordship may just see that decision, my lord.
Show that. Now they said that the guest lecturers can be subjected to periodic interview.
Just a second. Yes,
periodic interview.
I am citing.
Show that. Read that sentence. I really do not.
This,
somebody cited one decision that was not there.
Yes, my lord. This is a decision, my lord. In the case of Shiva Prasanna Party and
read that paragraph.
Yes, High Court University. There's a guest faculty
who are continuing in service for 4 years can be subjected to interview even for again continuing as guest faculty.
Yes, madam. She further submits that the guest lecturer is like a temporary appointee and hence he has no right to post by the state of Uttar Pradesh and so. She further submits that there is no rule of law that a temporary appointee has a right to continue till a regularly selected candidate is available. If a regular selection does not take place for 10 years, can the petitioner continue for 10 years? In that case, the sanctity of appointment of guest faculty shall be destroyed. This is not the correct legal position, but the legal position is clear that a temporary appointee has no right to the post. In other words, he has no right to continue even for 1 day, far less having a right to continue till the regularly selected candidate is available. The service of a temporary appointee can be terminated at any time because he has no right to the post. She strongly disagrees with the contention of the learned counsel for the petitioner that the guest lecturer have a right to continue till the regular selection is made. Then the finding. Heard the learned counsel for the parties, as submitted by the learned counsel for the state, there is no rule of law that a temporary appointee has a right to continue till a regularly selected candidate is available. The submission of the learned additional government advocate seems to be the correct position of law, even if contrary view might have been there in a particular case, as has been referred to by the counsel for the petitioner, citing as a binding precedent. If in a particular case, having considered the peculiar facts and circumstances of the case, and the appellate court might issue direction without laying down in the principle of law, in that case, such direction cannot be treated as precedent. There is always a danger in treating them as precedent, even though it is a judicial utterance based on facts of particular case. Then paragraph 13. And there cannot be an absolute rule or principle that one ad hoc or temporary appointee can never be replaced by another ad hoc or temporary appointee. For example, if a temporary appointee in service is incompetent, can he not be allowed to replace?
Correct. That is not your case.
Well, unless an interview takes place, how can I know that if somebody is better or somebody is...
Under which rule?
Well,
under which?
Well, the scheme is there is for 3 years. I have annexed in Annex REIT application, Annex 1, there is a scheme, self-financing.
Matter requests deeper consideration. Matter requests deeper consideration. Call the same in the first week of July 2026. Request consideration, but I don't agree with that view. Anyway, let us see. We don't know. We are yet to see that. Yes.
Note kar deta main now.
Yes.
Item 19. Your lordship, you should notice in all the matters. Item 19, we have filed a miscase for change of the name of the container. That if notice goes in the wrong name,
Serial number
19.
Serial number 19. A miscellaneous petition supported by affidavit is filed seeking to add
change the name of the container.
You are changing his name.
Yes,
you want to call him as Y, or you want to add new man.
New name, but he was not
change of this.
Yeah. This case number 289 of 26.
Addition of the appropriate contemner in the place of one already arrayed.
Wrongly.
By way of amendment. First, public petition is allowed and permission is granted to the complainant to amend the cause title immediately. First off, if amendment takes place, issue police notice, returnable within 2 weeks, and post the matter on It goes a little longer, it should be.
Oblige in the, I mean, because contempt is item number 71.
Today,
Yes, that is lying on my head.
that matter. That would tap to this.
My lords, may I mention item number
Your
32?
Lordship, we started in such note. This is a matter 67. It is complied, Your Lordship. So, Lordship.
67 is complied with.
Yes, Your Lordship.
What
We
is
have
the nature of complaint? Just I
We
want.
have already
If
paid.
it is an IWASH compliance, I will not be proceeding. Yes.
Lordship,
Because we have been seeing how it is compliant, etc.
it has been, he has been forward with that amount, Your Lordship.
How much money is paid?
2 lakhs somewhat, Your Lordship. After
No, that
he
was
gave
said
a-
last time also.
Yes, Your Lordship. He gave a registered power of attorney, Your Lordship. After that, it has been remitted to his
Amount is
account.
remitted.
Yes, Your Lordship.
He says amount
That is only the third part. The two parts are still left.
Which part?
Which are the two parts?
May I read? In the above circumstances, the execution case has favor of the following direction. The judgment debtor shall supply to the decree holder the quantity of logs of woods under the forest contract in question in terms of settlement as recorded in the apex court in civil appeal number so and so, disposed of by common order dated so and so through the Odisha Forest Development Corporation or such other agency within 3 months, subject to deposit of stipulated payment being made good by the decree holder with simple interest of 6% per annum reckoned from 22 to 1997, the date on which the execution case number 3 of 1995 was dismissed. Alternatively, the judgment debtor shall pay the decree holder within 3 months the present market value of the quantity of logs of the nature minus the deficit payment with interest component to be computed as mentioned in the preceding direction. The third direction, the judgment debtor shall pay by the decree holder within 3 months a sum of rupees 2 lakhs only by way of exemplary cost, since they
Cost is paid.
Yes, that is
Not that compliance.
exact. That is what I was.
No compliance. The next date we look into something we'll do. All on 37. See, in the meanwhile, if they do well and good, otherwise, we'll leave it to your elements.
My lords, may I mention item number 32?
Positive note, but then.
Yes, we'll go always. No, officers should comply with the
Yes,
office
yes.
of the court.
Yes,
No, Lordship is-
Otherwise, who will
Lordship.
care? They don't care the High Courts at all.
Yes, Your Lordship.
Your officers think too much of themselves. Or not all. There are very good officers also. A section of the officers, they think that they have landed from heaven. They are not.
Auto collector is there.
They are not. They are not. They are not.
In fact,
They have come from some desert.
in fact, I have also petitioned for attachment of salary under order 21.
Oh, I may do that on the next date. Let us see what
My
subject.
lords,
What?
may I mention 6 item numbers, please? Item number 32, 33, 34, 35, 36, and 39. My lords had issued notice today in the contempt petitions. A similar matter against the same impugn order is listed on 1505 before my lords. All am requesting to tag these 6 petitions with the same contempt petition, my lords.
15?
05 next week, my lords.
No, but contempt to go, madam. True.
Contempt.
But notice under your rules, we have to give reasonable time to them.
Obliged.
Let notice be served. Then we will see what we can. Right. Compliance
Not
done.
Not fully complied, my lord.
Not fully complied.
Lordship. They have taken steps. Well, that matter relates to, my lord. They have alleged that the
government road constructed in his private land, my lord. That has to demarcate it, my lord. Lordship can see, my lord, the page 2 of the letter issued by the collector, my lord. In evidence, my lord, page 1, my lord, sorry, page 1. In obedience to the order dated 7/5, collector Baleswar had heard the case on 8/4/2026 in office premises in presence of the petitioner, Superintendent Engineer RD 1 Baleswar, Tahsildar Sadar Baleswar. During hearing, the undersigned has directed SC RD Baleswar and the Tahsildar to demarcate the land for dismantling the constructed CC road portion of the petitioner bearing plot number such and such under Chanwa RI Circle, Baleswar on 9/4/2026. The STO RW subdivision Baleswar and additional Tahsildar Baleswar attend the above plot along with JCB and labors towards dismantling the constructed CC road portion of the petitioner land. But the local people, both male and female, within bracket, of that village of nearby 10,000 protested the dismantling work. The copy of the letter submitted by the Superintendent Engineer RW Divisional Baleswar is annexed as Annexure A1, my lord. And thereafter, my lord, suggestion of the last premises, my lord, the last paragraph 3 on the above facts and circumstances, the undersigned obeyed the order of the court order. Accordingly, 15 days time may be allowed to comply the order dated 7/8/2025 passed by the Honorable High Court of Orissa Court of Order. That they have taken step to comply, my lord, because of the people's objection. They have protested and they have not fully complied, my lord. They have not fully complied. Lordship, I will glass lordship's order dated, my lord. Lordship directed to consider the grievance of the petitioner, my lord. Now you have considered the grievance. I have considered not pretty practical, not partly fully considered. Yes, my lord. Not fully. Not fully. The people protested, my lord, the dismantling of the road, my lord. He alleged that his private land has been, road has been constructed, my lord, over his private land. Which is that order, my lord? Order. Lordship, page, my lord. Page 9, my lord. No, this is appointment order, which you have given. No, that is item 70. This is 17. Lordship. That has been completed. 16. 16 is pass over. That is 17. My lord. This is 17. 17 pass over. 17 also, my lord, that have complied. I'm sorry, my lord. 17. This is 16. 16. Now, what you have done in this matter? But, this matter, my lord, the collector has taken steps to comply with lordship's order, my lord. Only, my lord, another 15 days they have prayed for. That I have placed, my lord. Partial compliance is reported by the collector and district magistrate Baleswar. By the collector and district magistrate Baleswar. My lord, opposite part of 3, my lord. Contempt number 3. First off, Lord, the ASC appearing for the contemptor, head contemptor submits that if 3 more weeks are granted, full compliance should be reported. First off, call after 3 weeks. Call on to 3:30. Last one. I have obliged. But 17, I have complied. I have not mentioned the lots. The complaint alleges non-compliance of the order dated 20/11/2025 entered in complainant's WPC number 30580 of 2021. First off, essentially the direction was for consideration, and such consideration having taken place, order bearing number 490, date number so and so, bearing number 497 dated 6/4/2026 has been passed on the representation. First of course, no substantial relief has been granted, substantive relief has been granted to the petitioner
And reasons are assigned for this in the body of the compliance order. First off, in the this court exercising contempt jurisdiction cannot undertake critical examination of right or wrong of the order. First off, in the above circumstances, this complaint is dropped, reserving liberty to the complainant to assail the said order elsewhere in accordance with law. First off, in that connection, all contentions are kept open. Have you sent copy of the order to the complainant?
That is the memo in the there, madam.
Registry to share a copy of the compliance order with the contemptor if he applies for. Okay. Why your officers do not send those orders to the contemptors?
They have sent any memo itself.
Have they sent that?
Yes, madam.
Only they write it, but the in 3-4 matters they have not sent earlier.
Yes, but I will again send the copy is there, my lord. Memo number, my lord. 498 dated my lord 16/4/2026, my lord.
It is sent.
Yes, my lord.
What is that memo number?
That memo number is the itself, my lord.
No, what is meant by that memo number?
Memo no copy forwarded
By virtue of the forwarding letters.
That
So
number is
number of the person, that is the
forwarded to petitioner should not to
From 70, contempt 454/2028.
My lord, this contempt, my lord, raises out of writ petition praying for compassionate appointment. Though writ appeal has been filed, but no stay has been granted.
When matter
delayed.
posted?
It's on the memo filed, and I mentioned made, no date has been assigned yet. And in view of your lordship's order on 24/4, steps have to be taken otherwise. So I pray for that. Because on the memo, I have not got a date yet.
So you comply with this order subject to outcome of the appeal.
Your lordship may grant me 10 days time at least.
For compliance.
Months.
Learned panel counsel appearing for the contemners.
Contemners. Two
contemners. Submits that the compliance of the writ shall be reported on the next date of hearing, subject to outcome of the pending writ appeal, in which order against whom the violation is alleged is put in challenge. First off, non-compliance of the order in terms of the undertaking given this day will be viewed very seriously on the next date of hearing. Call on 3/7 for reporting compliance. Yes. Instead, what we can do is, in your benefit, I am telling you, now we will drop the proceeding with liberty to revive it for aggravated contempt, so that you will get more money.
My lord, I can hand over one judgment of Honorable Apex Court
For
on
what?
the contempt, only.
Saying,
Yes, my lord, that with the delay in filing the appeal, that has become the habit, and it has been treated very strictly, my lord.
now we have seen the contempt law is well developed, a year, etc. The
Yes, my
contempt
lord,
law is a
criminal
slippery law.
contempt.
Slippery law. It is a
My lord,
slippery.
only in the ground of,
Therefore, what we will do is, we
Yes.
will drop it at their instance with liberty to seek its revival for the aggravated contempt. Two things, because there is an order which they have not complied with.
yes, ma'am.
They said that they will comply with, and that also they have not complied with.
Yes,
You
ma'am.
can have aggravated contempt for which you will get more money. That way.
That situation may not arise.
No, we don't.
Yes, ma'am.
You may do that. Universities are up to
No, at least I cannot.
above circumstances.
I'll never bow to your lordship that ways.
The contempt proceedings are dropped with liberty to the contemptor to seek their revival by moving a memo for the aggravated contempt.
Yes, ma'am. Grateful.
That way, that helps you. At least your client will get money. While you put 1 lakh rupees.
To that extent,
No,
your lordship, I will definitely not
Contempt, no mercy, whosoever it may be. Yes.
My lord, order dated 23/9/25 having been violated, I have filed a contempt. And on 13/2/26, order kindly have a glance. You also issue notice. And caution was there to compliance, but till that the order has not been complied. And you'll also basing on which
Consider the representation.
basing on which you'll also already ordered the past. In that case, the comment has already implemented.
My lord, I have ascertained that in a similar matter, when my lord has passed this order, this has been complied to.
Implemented.
He's saying that. What you are saying is that only.
My friend also served the copy upon me, Mona, that I have collected. Accordingly, 15 days time be granted. Accordingly, this same may be complied.
You will comply with
Yes, ma'am. Because similar matters, they have already complied. There is no need to discriminate this person.
Yes.
Cannot be.
Kindly have a glance that has already in another case, basing on which you'll also already ordered.
Because of contempt they have complied with.
Yes.
Yes, ma'am.
The complaint involves violation of the order dated 13/2/2026. Sorry.
23/9.
23/9.
23/9.
25.
2025, whereby complaints WPC number 25992 of 2025 has been disposed of. First off. Next paragraph. This court, go to the next order.
ଦିଟା ଯାକ କେସରେ କରିଦେଇଛନ୍ତି ବିଜୟ କେସରେ
This court, while order dated 13/2026, had said as under. Next paragraph. The above court notice having been served on the contender, they are now represented by learned AGA Mr. Mohanty, who very fairly submits that the order in question would be complied with within 2 weeks, as has been done in respect of a similarly placed person in contempt case number 5040 of 2024 between Sushanta Kumar Panda versus state and others. First, believing the promise given by the contemners through their counsel, this proceeding is dropped with liberty to the contemner to seek revival thereof for aggravated contempt in the event the order is not complied with and assurance is not put up, not kept up.
Item 73,
73 also similar.
Same order.
Same order dated 24/9/25.
24/9/25, WPC 26073 of 2024.
Yes.
Rest of the things same.
Item 74, content 556 of 2026.
74, my lord, we have filed the.
Let's see if item 74 pass over for a moment.
My lord, we have complied the same by our order dated 19/3/2026.
74.
Yes, ma'am.
What was the order?
Not specific order was.
Court of Prison Liberty to make such representation to the within 2 weeks and shall be considered by the OPC within 8 weeks. Yes, did they give the representation?
Yes, my lord.
And you consider the representation?
Yes, ma'am.
Where is that order?
My lord, Annexure A dated 22/2026, ma'am. At page 4 of the complaints.
What's the complaints?
It was filed on 23/2026. E-filing was done on 20th March.
Where is the compliance order?
You'll have that Annexure A, page 4 mill. Kind of.
Page 4. Compliance affidavit.
Yes.
Where is the order? Annexure A.
Annexure A, Miller. Page, it starts from page 4.
Complainant's WPC number 26220 of 2025 came to be disposed of. Wide order dated 13/10/2025.
Yes, ma'am.
Directing consideration of his representation. First off. After service of notice, compliance affidavit has been filed, which is accompanied by a copy of order number 5465/WR dated 20 February 2026 at Annexure A, whereby consideration has taken place. First off, the critical examination of the order cannot be undertaken by the contempt court. First off, in view of the above, contempt proceedings are dropped with liberty to the complainant to lay a challenge to the same elsewhere in accordance with law. First off, in that connection, all contentions are kept open. Next.
75, content has 62 of total 26.
And the order dated 19 November 25 has not yet been complied with.
With your lordship, Miller, that's a press content, Miller. May I pray for some time, Miller? Comply. It's a order dated 19/11/2025 at page 9, Miller.
Notice already served.
19/11/25.
2025, Miller.
How many days time was given?
So, Miller, the time was given for 8 weeks, Miller.
8 weeks.
8 weeks.
8 weeks will be over. That is
8 weeks over. It is by end of December, Miller.
16 January 25. Not even 16. 14 January 2025.
Yes.
26.
26.
Now we are in May. What has happened?
Well, up-to-date information, though it has been communicated, up-to-date information I don't have.
Who is the?
May I pray for?
Who is the same secretary?
Same. Tirumala Naik. Same secretary.
Why we will pass some strictures against him?
May I pray for better Monday?
No, why are you keeping such secretary? You send him to some substandard organization.
Well, Monday is there for the personal appearance if at all it will not be compliant.
No, in how many matters he is not compliant? He has taken the courts for granted or what?
In the education department, more matters are there in the High Court.
No,
So many of the matters are kept. I'm conscious.
Yes. Is he not taught in Dehradun to comply with the court orders in training? Or he thinks what the judges will do for them?
Not that way.
Huh?
On this matter on Monday, at the request of learned AG appearing for the contemners. Or you will comply with if time is given, what will you do?
Time that by that, because Monday will be there, definitely there will be pressure and we can put it in the
What will the compliance?
This is the page 9 million.
The same cannot be denied to sign.
Page 10 million. Page 10 is the operating.
Page 10, paragraph 2. Learned counsel for the petitioners.
Observe therein in any new scheme oblique project. That was the specific order of my lords.
Because you have harassed us. Many days we waited for you. This court order also coordinate order.
No new scheme.
So
New scheme is there. It's a government policy.
We will take that
3-7. By 3-7 you should do that.
3-7.
7.
Yes.
Call this matter on 3-7. On the assurance of learned AG appearing for the contemner that something would happen positively in the matter. You should challenge the order. That you do not do. Or you should comply with the order. That you will never do.
76.
76. Is content petition arising out of that matter wherein writ appeal is pending that 197 of 2024 that Sharath Parida and the writ appeals are pending. May I pray that I would think that outcome, these two content petitions.
This also appeal is filed.
Exactly. That Sharath Parida and Hemant Chotra, which is kept pending to the month of 197 of 2024.
24.
13th.
We have put it on 13th. Call this matter on 3-7. Let us see what will happen to that. Next.
Both the matters.
Both the matters because
6 also.
16. And that is the analogous.
77.
Lordship, I am appearing on behalf of Dr. MISHRA, wherein the order was to get complied, but the compliance order itself speaks that the order is not being complied. I would like to take Lordship's attention to the last line. Since the petitioner is granted notional promotion to the post of senior clerk with effect from 31st December 2019, and he has completed 4 years of service in the post of senior clerk as per the rule 1999, his case for promotion to the post of head clerk be placed before the review DPC. And the review DPC should be conducted at the earliest within 4 weeks. This is passed on 19th of March, and we are 10 days short of 2 months from this date. Till today, no DPC has been conducted.
This is by virtue of the compliance order that we have filed, but my learned friend is submitting at Annexure A.
Even according to you, DPC has not made. What was the order?
The order was to consider the representation.
Representation in the time-bound way. If at all the contemner kept open with the proposal learned counsel for the petition is also agreeable.
Where is the consideration? Consideration has to happen at the hands of the DPC.
Yes, one.
They have not constituted the DPC at all.
DPC is to examine his eligibility in accordance with the...
Yeah, DPC will look into.
Because although it is in the month of March, Mila.
March is over, April has come, May has come, June is coming. Julius Caesar is dead and gone, in July is introduced to the Gregorian calendar. but nothing happens.
May I take a chance for further instruction in the development in the UM?
3.7. If the reluctantly adjourned to 3.7 at the request of learned AG. No, nothing is. Yes.
78, content page 2, 3 of 126.
Emergency notice was issued on 22nd, 2026.
27.2.
Yes.
What was the order?
This is for first time.
Consider the representation.
This is
For appointment of the rehabilitation assistance scheme.
Yes, where is the consideration?
Though it has been communicated, but instruction we have not received. The first time it is coming.
First time it is coming.
No.
It was notice was issued, no?
It is on 27/2.
27/2/2026 we have issued notice.
Posted on 23/2026 mail.
And notice gives a warning also. Non-compliance of the order is an offense. We make it a warning notice actually. We have framed a new format for the notice. For every notice, I have framed a format now. Caution.
That your lordship has passed in many cases.
So even that they don't care.
Here ballot notice was issued
like that
on 27/2.
Correct. What has happened? They are increasing the work of the judges. Your officials, executive officers are increasing our workload. They do not doing anything here.
3137, because it is rehabilitation assistance. In the meantime, that
37
dispute has already been settled.
Same order. So nothing is happening, Mr. Really, I'm not happy with your officers.
In some department, it is difficult on our part to make it executed, particularly this education department. Still then we are trying our level best to make it convenient by executing the order.
But really, what is the difficulty? Really, we don't appreciate.
Series of matters, it is being piled up with the department. Because for last couple of years and couple of months also the matters are kept pending. When it is being revived, it is very difficult on their part to make scrutiny all these things and pass necessary order at the particular time frame which has been given by this Hon'Ble Court. What I understood.
So we'll have it on 3.7.
3.7.
Okay. Before that, you have to do something.
Yes, exactly.
That order you print. Yes.
Item 75, content page 5 of 2026.
May I please your lordship?
Yes.
Your lordship, page 14, the operative part of the order, my lord. The order was passed.
Was filed.
Pritam Singh Bedi.
My lord.
Pritam Singh Bedi, State Bank. Okay.
Whatever shortfall is there in computing the qualifying service for pension, the same needs to be rounded up to the qualifying period, and thereafter the pension needs to be sanctioned and released. This is a matter of the consideration of controller of accounts, who is not a party to the proceeding. However, he, being not a party, would not come in the way of granting relief to the petitioner in accordance with the law.
Now what happened?
Now, my lord, so the show cause has been filed by the OP number 2, my lords, saying that Lordship may see page 7 of the show cause notice flag A. Now the applicant
A by 2. It starts from page 5. The operating page at page 7.
Now the applicant has filed C1TC 835/2026 for implementation of the order dated 20th/11/25, for which necessary instruction.
The controller of accounts, the papers have been sent to him now. Controller of account, we have directed him to do his job even when he was not a party.
And they are not the party.
But the controller of account returned back the same with an objection that orders from school and mass education department are required to implement the orders of the Hon'Ble High Court. Wait, what are the orders of the controller of
No, from the Department of School and Mass Education. What are those orders?
Return back the same with an objection. The orders from the school and management department.
Returned on 3/2/2026, February.
3/2/2026. That is the order of the BO which has been communicated to the additional secretary.
Then what happened? He communicated to him and the other person communicated to another person, but pension is not being given. After the documents were returned, what have you done? Monday.
Next week.
Monday. No.
Monday, Mila.
Monday, otherwise Monday order them to pay their salary to these people.
Today is Friday. Let it Thursday, 2 days time because Saturday.
Friday. Next Friday.
Friday.
Get the request of. Hereafter we will direct them their half salary will be given to these people. Yes. Till pension is settled. They have to survive, no? Yeah.
May I Lordship? On 2010-2025 order has not yet been complied, my lord. Your Lordship kindly see operative part of the order. Page 19, my lord. In the above circumstances, this petition is allowed
to grant regularization.
My lord. Rate of security is
the date on the petitioner completed 6 years of continuous. After that resolution.
My lord.
Yes, what happened?
Thereafter, you Lordship passed on 13/2/2026 notice, issue notice in police notice, my lord. Till today, that has not been complied, my lord.
My lord, take instruction. I have no instruction. Only notice was issued, and the same was also communicated by the AG officer also. We have communicated the same.
Thereafter, again listed on 20th February, my lord.
Contempt notice was issued on 13/2/2026 and it reads as that. After service of notice, the time was sought for and accordingly matter was called on 20 March 2026 and nothing happened. First, today matter is again posted and nothing has happened. Who is a person who should come?
Last is 13/2.
13/2 order was, no, 20 February 2026. Thereafter, one more adjournment is granted at your request.
My lord, the same person. Here is same person.
Same person. No, something has to be done to him. This court has been observing recalcitrant attitude of the contemptor Mr. Tirumala.
Tirumala Naik.
Who is that?
Dr. N.T. Naik.
N.
Tirumala Naik.
Dr. N. Tirumala Naik, IAS. First up, on the next date of hearing, if compliance is not reported, he runs risk of arrest and detention. In addition to an order being passed for restraining him from drawing any salary. First up, call this matter Friday. Next Friday.
Your Supreme, along with the DO, my lord. Along with the DO, District Education Officer, my lord.
Higher authority will comply, then it will be automatically complied. But the secretary is coming, then no need to.
Open number 3.
Yes.
Why
this vacation you go to some that Tirupati temple and make prayer?
Sadhudi.
Sadhudi to this Tirumala. Yes.
Here, my lord, order has been complied.
Why is there any problem with that officer? Whether really has got problem or there is a tremendous workload? What is that?
Tremendous workload. As I know, it's
on speaking about them.
Tremendous workload. I cannot say other problem. I don't have the knowledge.
My lord, they are creating the workloads. Suppose a contempt notice has been issued, they outrightly reject the representation, and again the petitioner come to the court. Again and again they are coming. And 60% case of the education department has been pending. They are getting pleasure sitting in the glass house and taking tiffin in the golden spoon, and the lower stage the litigants are very surprised.
Your paragraph 3.
My lord,
here, my lord.
Paragraph 3.
Here, my lord, compliance order has been, my lord, filed.
Can I
My lord, page 9
23,
of the order,
2026.
Lordship said that if the similar situated persons have been granted the IACP and grade pay of 4,200, the same should be extended to this petitioner. And keeping in the view of the annexure 4, the Lordship specifically directed. And also in the above circumstances, petitioner is disposed of a period of 2 months is prescribed for consideration the subject prescription at annexure 6 and also to inform result of such consideration to the petitioner. To facilitate easy and effective consideration, petitioner is at liberty to file a comprehensive petition along with the materials vouching his claim within 2 weeks to the opposite party number 2. All connections of the parties are kept open. As for your lordship's direction, the petitioner has filed a representation under 29/2025.
The order has been passed. We cannot examine whether the order is right.
My lord, your lordship has not in true spirit, they have considered. Number one. Number two,
Order against whose violation is complied with, whose violation is alleged, having been complied with by the order dated, is that order compliance order?
9/9/2020.
Order number 7768 dated 19/3/2026. Correct?
No, my lord, 9/9/2025.
No. No.
complaint submitted filed 20th of March 2026.
Correct.
But
But the
annexure-
order is dated 19/3/2026.
That is annexure A/2.
Annexure A/2. With order number 26.
Order number is 7768.
Yes. Complaint is dropped with liberty to the petitioner to lay a challenge to the said order elsewhere in accordance with law. Since this court cannot undertake critical examination of the said compliance, examination of the order. First off, in that connection, all contentions are kept open. Next.
My lord, order dated 24. 2025 has not been complied. Your lordship directed to pay 10,000 to the.
That also
That amount I'm giving.
Not complied.
No, your client might have said, told.
No.
He's saying it is compliant.
Yesterday night, I over a telephone talked to my client that they have not.
Show it to him. This court, however, notes the compliance of the direction for payment of cost of rupees 10,000 to the complainant. Or next.
Lordship's order dated 23/9/2025 has not been complied with, my lord. Last occasion on 10/4/2026, my lord passed the order, my lord.
82 million, we have filed the so-called reply on 12/3/2026.
Then what happened?
Here, my lord, office order was first kind of a glance to annexure B, dated 10/3/2026.
2026.
It is at page 10.
Page 10.
Page 10 of the so-called reply affidavit.
No, what have you done? What was the order and what have you done? What was the order?
10/4/2026, my lord. Last order, my lord, your lordship.
No, 23.
10/4, my lord.
10/4.
10/4/2026.
10/4 to 10/4.
Specifically directed, my lord, to grant the pension, my lord.
Yes, Mr. Mohanty, kindly come to page order dated 10/4/26. Our order, court's order. In fact, G's undertaking is recorded here.
Yes.
Who is the contemptor?
Director, my lord. Director higher education.
Parul,
My lord, have a look to the order dated 10/3/2026.
thereafter 10/4/26 is made.
Compliance be filed.
Mr. G undertook that everything will be done. Compliance affidavit is filed now.
Lord, it is at 9/4/2026. Latest one. Further so cause reply.
On 25/2/2026, you have issued a letter sanctioning the unutilized leave of 300 days in favor of the petitioner, and his pay fixation was completed on the basis of the material supplied.
Yes.
3,20,000 has been paid. The same was sent to the officer commanding NCC. Said letter, it was requested to furnish the pension papers of the petitioner by 30/3/26 for its onwards transmission to the office of principal AG. Above said actions taken by the opposite party have been intimated earlier in the show cause note affidavit dated so and so. Thus, is humbly submitted compliance with the government order so and so. Requested the petitioner to furnish the necessary documents. Which documents we were asked to produce?
I have already submitted the documents, my lord, and
When?
they have.
When did you submit the required document? Now 3,20,000 is paid to you.
And 12 is the page 12 is the latest one. Preparation of the final pension documents in respect of X. Page 12.
12.
To the latest so cause reply submitted on 9/4.
Page 12.
Yes, ma'am.
Where is page 12? Page 11 is the last page.
No, my lord, thereafter. Further so cause affidavit filed on behalf of the opposite party number 1, the Director of Higher Education.
What affidavit he has filed?
May I permitted to supply this?
Why pension is not being paid?
No,
How many years of service you have put in?
Part 32, my lord.
32 years. This is the additional affidavit.
Yes, ma'am. 9/4.
Now what does it say?
Everything has been prepared, my lord.
Prepared
Yes, ma'am.
and kept in drawer.
No, my lord. It is in the process. Kindly have a glance to the last page, my lord, page 12. This is a letter of this office commanding officer to the petitioner concerned. Your fixation dated such and such has been received from the Department of Higher Education dated such and
Now
such.
how much pension is, where is pension fixation on? Where is the pension payment or PPO?
PPO.
What do you call it in your state?
PPO.
PPO. Where is the PPO?
My lord, page 8 can have a glance.
Page 8.
Page 8.
Form for fixation of pay under the Odisha revised scales of pay rules 2017 it is.
Yes, ma'am.
Where is the pension payment order?
PP order that it has not been annexed, my lord.
Next one. So,
But details has been given in page 12, my lord.
now where is the what we need? Pension payment order. You show it and we will drop it now.
My lord, but it transferred that it is in the process. 6th April 2026, we have very well communicated to the person concerned.
Requested to come to this office immediately with the
Following documents for preparation of the final pension,
and
same will be submitted to the director.
Bhubaneswar.
Yes.
Copy of bank passbook.
Yes.
Have you given those copies?
My lord,
When have you given? Give that.
I have already given on
Aadhaar
17th.
card, nominee details, passport photographs,
Individual signature from person, which is required.
When have you given?
I have given, my lord, 17th.
When have you given?
17th 4, my lord.
Huh?
17th 4, April, my lord.
17/4.
My lord.
We'll call this matter on Friday.
Right.
You have to tell what has happened. Otherwise,
If at all signature will be there and documents will be there on 17/4, definitely it might be processed. I'll take it. Let it be on Friday.
Friday.
Because it is in the process. There is no question of from the responsibility.
Counsel for the complainant submits that pursuant to letter dated 6 April 2026, his client has already submitted all the requisite documents on 17/4/2026, and despite that, the pension payment order has not been passed. First off, Mr. Mohanty submits that he would have instructions at the hands of his clients and come back, official clients, and come back immediately.
And that affidavit may be taken into record because online it may be taken into record now.
He has also drawn our attention to the affidavit. What do you call that affidavit as?
This is my additional so-called reply that it has been
in the affidavit.
This is further so-called affidavit because earlier occasion so-called reply was filed. This is the all the way development in the meantime that we have annexed in this affidavit.
Affidavit which is thoroughly wrongly titled. Along with certain documents which would not satisfy the court. Call on Friday. If compliance is not done, the concerned secretary of the, who is that, secretary or department?
Department, my lord.
This is Director
Higher Education Department may be summoned personally. Okay. Registered to share a carbon copy of this order with the learned EGA for information and needful action. Yes, next.
My lord's order dated 18/11/2025 has not been complied with. Your lordship already quashed the order and directed the opposite party to give to consider the candidature for engagement, my lord, as the TGT, my lord. Till date, my lord, the matter has not been complied with, and last order, my lord, 10/4/2026, my lord. And your lordship has specifically directed to comply the order.
Go to 10/4. Despite service of court process in the matter, the complaints have not been considered. This is an act affront to the judicial process, to say the least. However, it's the request of learned one period of 2 weeks granted to do the needful. Yes. Who is the same officer?
But I gathered information from my learned friend that writ appeal has been preferred.
Preferred.
In item 83, writ appeal.
Preferred. Any stay has been granted?
No.
Then,
not it.
Then unless stay is granted, compliance has to be, that's what Apex Court has said.
Yes.
By filing of appeal under the oldest CPC, filing of appeal against the decree would automatically result into suspension of its operation. But that is not the case now.
The latest one 15 days back, my lord, the Honorable Apex Court has
said you have to comply with the order. Counsel
Like here
for the contempt.
total W has been filed, what I gathered in
That's
some time.
Against the order whose violation is complained of, writ appeal has been filed, and therefore a short accommodation be granted. First up. Call this matter on 3-7. For reporting compliance,
84.
unless the order complained of is stayed
84
by the appellate court.
Sanskrit. No.
84.
84 minute we have filed the compliance affidavit on 6-4. 6-4 minute.
Challenging.
6-4 minute.
This
6-4.
the order whose violation is complied of, having been now complied with, the order whose violation is complained of, comma, having now been complied with, by the office order dated 9/3/2026, a copy whereof avails at Annexure 1 to the compliance affidavit, comma, the complaint is dropped with liberty to the complainant to lay a challenge to the said order elsewhere in accordance with law. First of all, contentions in that regard are kept open. Next.
The 95 content 1 into 26.
Your Lordship's order dated 16/9/25 directing to give appointment to the petitioner has not yet been complied minor.
What was the direction?
Direction to give appointment and approval within 3 months minor.
Read. Go to the operative portion of the order.
Minor. Page 14 minor last para. In the above circumstances, this petition is allowed a writ of accessory.
Mandamus to appoint the petitioner.
Minor.
Within an outer limit of 10 weeks.
10 weeks in any of the school enlisted by the District Education Officer Baleswar or any other school.
Yes, Mr. G.
One Shokas has been filed, my lord.
Shokas.
Shokas. My lord, Shokas is that the
Last occasion they submitted, then writ appeal is pending, my lord.
Writ appeal is pending.
Last occasion submitted in order number 2, Lordship kindly see. The order number 2 dated 13/3/2026. Merely filing, only to say, without any stay order, merely filing the writ application, writ appeal.
Writ appeal 392 of 26.
Minor.
392 of 26.
Any interim order is passed?
No.
No.
Then you have to comply with your latest judgment you have seen.
I have seen that. I give some time so that
you comply with the order and subject to outcome
of the writ appeal.
That AGA Mr. G submits that the order whose violation is complained of is put in appeal and that the appeal is yet to be posted for consideration. First up, he submits that he would ascertain the present status of the appeal and come back. First up, for reporting compliance, call on 3/7/2026, unless the order is stayed. Okay. On 3/7, you have to comply with the order.
Yes.
The 96 content 1,500 days.
May I please, Your Lordship?
Yes, sir.
The Lordship's order dated 26th November 2025 has not been complied, for which on 13th March 2026, my lord, emergent police notice was issued with caution notice, my lord. Operative portion of the order, my lord.
The G order is very clear cut.
Very clear.
Yes.
Notice was on 13/3. Police notice
was 13/3, my lord. No SOCOs or compliance I had received as yet.
Which the office same.
That Tirumali is the secretary, my lord, but here director and the DO both have the content master, my lord. As because
the direction was issued to office 2 and 3. Lordship, I call you.
Please, one instruction I had received. Have been decided to implement the order dated 26/11/2025. That they were requested to take immediate steps, appropriate action to implement the order. The secretary, the director secondary education has issued a letter to implement the order immediately. My lord, and file compliance. This was given on 27/4/2026 to the DO Kyaunjar, my lord.
Why he has not complied with this? Our direction is not complied with his direction.
No,
not complied.
my lord. Lordship may give me some time so that I shall ascertain that the next Friday, Lordship may 3/7.
No, Miller, because what I understand, Miller, what my client today morning telephoned me that the DO has issued letter to the headmaster only to pay the area salary, not the interest. As because your lordship may kindly turn to the operating portion.
Friday we are calling, just look into.
My lord.
And then we'll, otherwise we may take action against. See, there is an order by the first contemner.
Yes.
Issued to the second contemner.
Yes, my lord.
We made direction. First contemner gave direction. The second contemner is not obeying. Maybe he wants something.
No, nothing.
It appears that way.
They are teachers after all. They will not pay money. My lord, lordship may.
So, learned AG, Mr. G submits that already steps are being taken for the implementation of order dated 26/11/2025, whose violation is complained of. Full stop. In view of that, call this matter on Friday for reporting compliance. Failing which, contempt number 2, second contemner. Contemners may be personally summoned for taking punitive action. Okay.
Yes. 87 is also same, Miller. Same containers, same order. 26/11 order. Obliged, Miller.
It is Miller, I am for the contempt. The same petition, Miller, arising out of the review petition has been admitted, Miller, your lordship directly. It has become infectious.
Already complied with?
No, not me. The contempt petition arising out of the writ petition, Miller, already review petition has been filed and your lordship granted liberty to file review petition. That was in item number. Yes, item number 54. Your lordship already condoned the delay and directed the opposite party
to take notice. So we'll call this matter along with that review petition.
The outcome, there is every likelihood of success of the review petition. So I pray that let the review decided. Thereafter, we will take, if the review fails, Miller.
No. How do you assume that review?
No, that is what I am saying.
Call this matter along with review petition number
77 of 2026 and 78 of 2026. Item number 54 of today.
Next.
Item 89. Contempt government section of 2026.
79 or same. 89 same.
Okay.
Item 90. Contempt government section of 2026.
May I please, my lord?
Yeah.
Order 13/11/2025 of my lords has not been
Consideration of representation.
Release of annual increments, my lord. My lord has positively statement observed that all if the increments are withheld only on the ground of pendency of departmental proceeding or criminal proceeding, that will be unjustifiable. My lord has observed that, my lord. And on 27/2/2026, the police notice has been issued.
Yes, Mr. G.
My record has not come.
Well, has not come.
Record has not come, lordship. Next week, your lordship may come.
Friday. At the request of G. Who appears for. Yes.
Item 91. Contempt government section of 2026.
May I please, sir?
Yes.
Sir, violation of order dated 10/12/2025 minutes wherein your lordship have directed to treat the period of suspension as duty and release all salary.
Now they have passed an order.
They have not. They have here, my lord, they have filed an so-called saying
Compliance affidavit.
that they have decided to implement, and the direction has been given to the principal to release my salary, but the order has not been complied. The petitioner has not got his salary.
The next day, now the complaints will be done if they do not do aggravated contempt. And you can seek revival for aggravated contempt. Now, they have issued compliance order.
They have directed to opposite part number 4.
For implementing
For
that
implementation,
order.
Lord.
So if he does not implement,
Yes, Lord.
now we'll record and drop the proceeding.
Yes, yes.
So you seek revival
Yes.
for aggravated contempt.
Yes, Lord.
Yeah.
An order has been, Lordship, may kindly have a look to the compliance affidavit.
Now, where is the compliance?
Compliance was filed, my lord.
Asking your lower officer to implement the order is no compliance.
No. It
It
is,
should reach the pocket of the litigant.
my lord. An order was passed by the Department of Higher Education. Lordship, may kindly have a look. Annexure A.
1903.
My lord, Annexure A, page 7 of the compliance.
Correct. 1903.
19,326. Thereafter, my lord, we have come next page, my lord. Whereas in compliance with the kind orders dated 6/5/2024 passed in WPC number so and so, the petitioner along with the principal Nabhakrishna Chaudhary College of Teacher Education Hon'Ble were intimated by this department letter number so and so. Whereas after perusal of documents and taking up hearing from the petitioner and other related officials, it was decided to regularize the period of suspension with effect from 10/4/2003 to 29/4/2005 with a treatment of the intervening period as per following manner. So and so, so and so. Further, it was sanctioned an amount of 42,10,380 financial benefit as due and admissible as in below.
No, that's the interim amount. The 2 years that will be.
My lord, thereafter, my lord, this order has been passed. This decision has been taken, and for the lapses of the principal of the concerned college causing procedural lacuna to treat the case of the petitioner in proper perspective, which had resulted in extension of public funds to meet the petitioner's cause, as the same shall be recovered from the hearing officials of the concerned college. Respond that this is the steps they have taken, my lord.
No, but what is actually money has reached him.
No.
If not reached, it will be reached.
That would be aggravated contempt.
My lord.
The complaint alleges violation of order dated
10/12/2025.
10/12/2025, whereby WPC number 27894 of 2024 came to be disposed of. First off, the complainant, who happens to be the petitioner, submits that only order number 15940 SE dated 19/3/2026, a copy whereof avails at Annexure A to the compliance affidavit has been issued. However, the financial benefits have not reached the hands of his client. First off, learned AGA submits that all steps should be taken to give effect to the order whose violation is complained of in terms of compliance order dated 19/3/2026 if a short accommodation is granted. First off, in the above circumstances, recording the assurance made by the contemners through through the learned AGA for complying the rate of the court, this contempt proceeding is dropped with liberty to the complainant to seek its revival in the event the assurance is not kept. First off, it is made clear that once revived, the proceedings would be for aggravated contempt. which may include levy of cost in thousands of rupees and an adverse entry in the service records of the concerned official.
Only time limit will be fixed. Only time limit to be fixed.
No, they have said no, within the compliance should be done within an outer limit of 8 weeks.
My lord.
Before July. Before July.
Huh?
Before July.
Zero paise.
6 weeks. 6 weeks.
6 weeks. You will get money according to the 6 weeks. 6 weeks.
Great.
Yes, sir.
It was ordered at 4925, my lord.
Yeah.
Annexure 5, sorry, Annexure 1, page 5, madam. The concluding part is at page 13.
With retrospective effect.
Yes, my lord. My juniors have been promoted. I secured highest mark. Juniors promoted.
Not complied with.
Not yet complied, my lord.
First time it has come or notice?
Notice was issued, my lord.
Yes, Mr. G, why that has not been done?
One so-called
file peculiar, we have filed a review petition.
It is not.
Peculiar so-called file, then we have filed a review petition.
No, that is not.
Yes, that is a. That is
that so-called have filed, we shall file a better so-called. We shall file a better so-called.
Show cause of it.
Yes. Or compliance
should show cause to them. This should be compliance of it.
My lord, I should come. Contempt, we should file.
No, why order has not been complied? So simple order. Give retrospective promotion. From the date his immediate juniors have been given. So simple. Even for that, show cause and other things.
My lord, here there is an instruction to me to take this matter along with that review petition.
Review is filed?
Yes. One review petition.
Filed by whom?
No, it is not there on record. By the state.
State has filed the review petition?
A review petition. So your lordship, a review petition number 83 of 26.
Call this matter along with review petition number 83 of 2026. 2026 on 3/7/2026.
Next week, review that next week.
Next week, impossible. Calendar is full. Yes.
94, content 1/1 of 2026.
My lordship, kindly see the your lordship order.
Here, my lord,
25/11/2025, lord.
Here, lordship may pass orders. Some orders your lordship may pass.
It is family pension, my lord.
I know. I had taken the responsibility. Today, I am suggesting to pass some orders.
Who is the officer concerned?
Dr. N.
Yes, there is one sanction authority there.
Yes, sir.
Why pension is not sanctioned? Your office it is.
No. Yeah, PS not submitted the documents before the accountant general. That's why that has not been released.
PS means?
PS means
Pension
employer. Pension sanction authority.
Who is the employer?
Employer secondary school.
No. He is not the employer. The appointing authority is somebody else.
Direction has been given.
Direction.
To all the opposite party.
No, all the here, OP number 2, Director Elementary Education.
OP number 2.
Madam.
Paula Mukunda Bhuyan.
He submitted the documents. My OP3 submitted the documents before OP2. Then he forwarded to accountant general.
OP2 has forwarded to whom?
To accountant general.
He has submitted already.
No, not submitted.
He has not submitted.
Not submitted. Here the direction to your lordship, OP number 3, to submitted all the documents before the Bala Mukunda Bhuya. He will transmit the document to the accountant general, then it will be discussed.
For deciding the pensions.
That's the procedure.
The
May I just interrupt for a moment, my lord? I'm also appearing for the Accountant General. Here, what has happened actually is opposite party number 5. He has been shown as the Accountant General A&E, and the name has been given as Atul Prakash. But actually, Atul Prakash is the Accountant General for Audit 2 Department, my lord. So that has to be first rectified, because otherwise he has received the notice from this court. He is no way connected with this matter, my lord. So that may be kindly observed.
Who is concerned with this?
Accountant General A&E.
Accountant General A&E, that is Mr. Dinabandhu Sahu. He is the AG A&E, man. Principal Accountant General.
The complainant is directed to array. Who is that person?
Mr. Dinabandhu Sahu. He is the Principal Accountant General.
Dinabandhu Sahu.
Yes, my lord.
Accountant General.
No, he is the Principal Accountant General.
Principal Accountant General.
A&E.
A&E. Orissa. Janapad. Bhubaneswar District Khurda. In the place of present contemner number 5, Mr. Atul Prakash. First up, who appears for him? Issue police notice.
Unnecessary to issue notice. We are appearing for the Accountant General, along with my senior.
You appear for this person now?
Yes.
No, actually, both of us are appearing for the accountant, because I am also the senior standing counsel. So what I'm trying to say, because Dinabandhu Sahu never got this notice, my lord. This
now we notice now.
Yes, notice can be issued, then he can appear and give his reply, whatever he has to give.
To contemner number 5. Five. First up.
Your Lordship, we may dispose of the matter with the direction to processing the pension paper and submit the account.
No, there is order. They have not. They don't care High Court's order.
Oh.
So the problem is actually we have got nothing to do until we receive the papers, whether it is Atul Shukla or Mr. Sahu. Until the paper receives our organization, that is the AG Orissa, we are helpless. In fact, we have written a letter to the concerned department asking them to do the needful as per the last direction, my lord. We have issued that letter. I'll just tell you, my lord. That letter has been issued on 7th of May. We received the notice on 6th May, my lord.
Learned counsel appearing for the complainant submits that the contemner number 2, Mr. Bala Mukunda has not submitted the pension papers of his client, though the contemner number 3 has already submitted the said papers to his office. First up. Learned senior panel counsel appearing for the contemner, then police notice need not be issued. You appear for them.
Yes, sir, because we have not received it.
On request appearing for contempt number 5, submits that even his office has sent a letter dated
on 7th of May, my lord.
7/5/20.
Two letters, one 31/12/25, then
31/12/2025.
Another letter, another DO letter, 7/5/26.
7/5/2026.
To the secretary, to the opposite party number 1, my lord.
1 to contemner number 1. Soliciting the papers for processing the claim for pension of the contemner. First off. However, nothing has happened in the matter. First off. In the above circumstances, OP numbers 1, 2, and 3 are directed to be personally present before the court on Monday.
Sometimes may be given.
On Friday. On Friday. Along with the required files.
If not completed. If not,
what steps have been taken towards the implementation of the writ of this court? First up. non-compliance may result into some stringent punitive action. All right.
If the order is.
However, in the meanwhile, the order in question has been complied with, the presence of these officials shall not be necessary. All right.
Our appearance will not Mr. Senior Advocate and
Yes, yes, we have taken. Heard learned complainant, learned EGA for the official contemners, and learned senior counsel appearing for
Accountant General.
Office of the Accountant General.
And escape after myself is the escape.
Assisted by Sri so and so.
It will come on Friday, my lord.
Friday it will come. Friday something happened to these officers.
My lord.
God.
May I please, my lords? May I please, my lords? The order dated 20th November 25 has not been complied regarding counting the period of service in a certain period to grant the pension benefits. I have retired in the meantime during continuance of the petition. But till date, the order dated 3/11/25 has not been complied. As a result, I am not getting pension. So order dated 20/11/25.
2011.
Madam, page 12.
Petitioner service.
Madam.
From 7/10/97 to
6/10/2007.
2007. 10-year service. Yes, Mr. G, what has happened?
I have the instruction that it has got nothing, no value at all.
No value for the court order also?
No, for me. My lord, here. May give me some time because to file compliance, because they have written that the higher officers have said that to prefer appeal. I will insist them to implement the order.
Okay. Learned EGA appearing for the contemner seeks a short accommodation, hopefully to comply with the come out with compliance report. Yes. Call on Friday.
Friday, very short.
37. Okay.
6 has been answered. Item 97, Contempt 145/2026.
May I please, lords?
Yes.
Order dated, my lords, 11/12/2025. The representation was pending for counting the past service, my lords. And that representation, your lordship has been free to direct the petitioner to submit a order of
presentation and pass order on that.
That
has not been done. Mr. G, what has happened?
Were issued on 13/3, lordship. 13/3/2026 police notice was issued.
Even when police come and give notice, even for that also no restriction. Then we have to call army.
So give me some time.
37. Let the request come. Next.
97, 98, same, lords.
97, 98.
3 connected matters have not come, lords. I am giving the numbers.
Give that.
Grateful, lords.
Call on 37.
Grateful, lords.
Next.
I am for the petitioner.
Petitioner.
Yes.
In contempt, there is a petitioner.
Contempt, yes. I am just every private party.
Private party.
Yes, here is the case complaint. What happened? Even though she got the highest mark, the opinion 5 has given appointment. Hon'Ble court has heard the matter and quashed the appointment order. Instead of dropping her, she has been transferred to some other place on a board, and vacancy arose, and they are not.
Look into then argues.
That's in a kindly.
Use it. Something has
They
been done.
communicate us that they prefer to file challenge the order. This communication after issuing notice by my lord on 12th, 10th, on 16th they wrote that inviting the reference subject secretary above, the undersigned is directed to say that it has been decided to challenge the order of 8/8/2025 by WBC number.
Into annexure A.
Writ appeal 157 of 2026 has been filed.
He intimated us that they are planning to file, but whether is filed or not, it is apparent. Nothing has been reflected. My one part is I am convincing that yes, they are preparing appeal about the order is all right.
No, they have filed appeal.
Is filed, but once a order has been this appointment has been cost, who is getting lesser mark than me, how she can report to another transport to another place?
Which writ appeal is filed, Mr. Chief?
They are filing the compliance affidavit. By passing that, they are saying that compliance.
It is a compliance affidavit. Your Lordship, on 11/12/2025, disposed of it by giving a direction in the above circumstances, writ petition is disposed of. Time for compliance 6 weeks, which would include communicating the decision taken on the subject representation to the petitioners. All contentions are kept open. So, my lord, in compliance to this order, they have passed a reasoned order. The government of Odisha Higher Education has passed a reasoned order. That
reasoned order is what?
The order is in there. It was a different case. Not a case of mine. Our case is Surama Das. It is a different case.
Surama. Sorry.
In this matter, what you have done?
Sit down.
You don't know whether this enlightened the State Council. I am serving a copy. That what the communication they have made. Is
see the letter which they have sent to him. We cannot implement this order because we want to challenge that order. Can they say like that?
No, they cannot.
But they don't know English also.
My lord.
Your officers do not know English also, let alone law and decency. And additional secretary to the government writes this.
Yes.
See the kind of language.
Right.
Additional secretary. He is additional secretary. Then FDC would write the proper English.
Let's give some time.
I'll call on 17.
And it's a concern the secretary is bringing this Dr. N. Thirumulla Naik, the IS officer. His matter has been explained to. So can it end up 15th, next 15th, it will be surprised by his
15th we are
next
15th.
One day he will appear, but my matter may be taken 50th, then something will be heard.
15th, you call this matter on 15th, let us see.
Yes.
No, what kind of English? What kind of sense? No respect.
Complete non-reflection of mind, that's simple their idea. Village.
In this case, my lord, order dated 10/11/25 has not been complied. Therefore, I have filed this contempt appeal.
What was the order, brother?
Your lordship may see page 14. Your lordship directed
this word of OP to call for a subject inquiry report in accordance with line.
My lord.
Inquiry report has been submitted.
Yes.
What action has been taken on the inquiry report?
My lord, thereafter, my lord. Data. Coding charges.
Charge, articles of charges.
My lord, the article of charges have been framed, and the district education officer also is directed to complete the proceeding immediately. Means thereafter, my lord, he will proceed with the proceedings.
Inquiry report itself is, where is the question of articles of charges?
There is
There is an inquiry report.
my lord.
There is an inquiry report.
No. Here memorandum of charges have been framed.
Pursuant to this, is it preliminary inquiry?
Preliminary inquiry report.
Preliminary inquiry.
Yes, thereafter.
Now they have taken the step.
Memorandum of charges have been framed. Yes.
Order dated 10/11/2025 entered in complainants WPC number 30758 of 2025 has been substantially complied with by framing the
memorandum of
charge memo against the delinquent officials concerned in terms of preliminary inquiry report. Person, Mr. G, appearing for the contemners, assures that the inquiry in question would be completed before long and suitable action would be taken against the erring officials. First, in view of the above, the proceedings are dropped. Next. This is serial number 101.
Here, Senator my lord, so that is 2007 to 2018 was not paid, and my lord directed to submit a directed to dispose of the representation, and they have not. My lord, they have in the police notice was issued, my lord, on 10/4/2026.
10/4.
Yes, 10/4/2026. And on 24/2026, my lord, the contender wrote a letter to the collector. And collector also wrote a letter to the district social welfare officer wrote a letter to the headmaster to pay the same. But till today the payment has not been paid, my lord, even though I have returned in 2019.
Yes, Mr. G. Next, on 15th, we will call this matter.
My lord.
On that day, the complaint should be reported. Call this matter on 15/5 for reporting compliance at the request of learned EGA, as requested by learned EGA. Yes.
102, contact 1780/2026.
My lord's order dated 25/11/2025. 25/11/2025. Your lordship, this is matter related to grant of pension, my lord. Retired from service 2002, my lord.
2002,
my lord, my lord.
Why they are not giving?
It's given only parents of the GR case, my lord, which has been already acquitted, my lord.
Acquitted.
My lord. Therefore, my lord, your lordship has already para 2 of the order, your lordship has clearly stated that. And therefore, directed the authority, my lord, to grant the benefit, my lord.
To consider the representation.
To consider the difference.
Representation. Accordingly,
Yes, Mr. G.
Accordingly, a complaint was filed by the opposite party number 4, the BEO Salehpur, saying that he has written a letter to sanction and release the final pensionary benefits in favor of the petitioner, retired teacher so-and-so, GPF account number so-and-so, in compliance to that manner.
When it will be done?
It was issued on 22/4/2026. Thereafter, my lord, BEO Salehpur also, whereas another letter, my lord, so-and-so in favor of the retired headmaster, service book, CID crime branch, and processed online, submitted the same to the controller of accounts for release of final pensionary benefits.
When are you going to release the pension? We don't want all this story at all. When are you going to
release? They have taken steps for release of the pension.
When it will be done?
Well, should I call this matter on July, in the month of July? So,
this pension?
Yes. 15 in such a short time, my lord.
To do, otherwise nothing will happen. Let your officers come in. Ask their personal presence, will ask who are the officers.
Dr. N. Thirumala.
No. What she will do?
He is the competent authority.
No. He is the secretary. What she will do? The pension sanctioning authority is BO.
BO has no role, my lord.
No, BU is a small
BO
portion.
My lord, he is the pension sanctioning PSA, the appointing authority. He will recommend the the records to the controller of accounts. He will do that.
Or drawing disbursing authority.
No, who should take the decision in this?
That should call this matter on 15th. Let me see.
Call this matter on 15th. Hopefully for reporting compliance. Since it's a serious matter relating to non-payment of pension for an employee who has retired in the year
On 15th.
2002. Right. 2002 he retired.
2002, my lord.
Yes.
Pay has not been revised, my lord. Also.
That is.
Aji sir, Aji, today we will speak. We will WhatsApp hear this matter.
No, we have.
Class certificate.
Huh? No, that requires hearing 3-7 we have that. 3-7.
2017 dismissed.
3-7 we have that.
377, yes.
3-7.
Maybe for the last chance and because case is part on.
At the request of learned AGA, that's the last chance. No, I don't remember anything. You said other day, Madhuri Patil and...
because I have collected a very precise note, matter is very short, because earlier the impugned order was quashed by the Hon'Ble Court.
How say the
SLC report, SLC committee by order in 2016, it was quashed by the Hon'Ble 2023. And in the present impugned order, the earlier...
It only replicates the same.
Yes, my lord, restored the same thing.
That's what the other day you said, no?
Restored the same thing.
Yeah.
So I have collected some very important state rules and act and the related documents to apply to your lordship. Very precise document, very short, very short also. So within if you give lordship may
3-7 we have.
Item 4, ma'am. Item 4. I was not there, ma'am. Lordship already issued notice. Item 4 of the today list, ma'am. Press contempt. Lordship issued police notice. But in the meantime, they have already passed an order by rejecting my claim, and that order has also been set aside by the coordinate bench by filing another petition.
So that has become infructuous.
Yes. Already
number 4. Matter has become learned counsel appearing for the complainant submits that the matter has become infructuous. Later developments having taken place. Well, first off. Accordingly, matter is disposed of. Proceedings are dropped. Or now we have issued notice now. You have to recall that. Print this order. Okay. So that matter has become infructuous.
Yes. Yes, they have illegally rejected. Now I challenge for the petition. Now
that's also
quashed matter, because that is not in accordance with the lordship earlier order. That is the direction.
Yeah.